Welcome to this question and answer review for the New Jersey Real Estate Salesperson exam. We'll break down why each correct answer is right, why the others fall short, and the reasoning behind it all. Here's the full practice set we'll cover: property ownership and title, agency and disclosure duties, contracts and financing, appraisal and valuation, landlord-tenant law. Quick reminder: our website has free exam guides and practice questions to help you pass your New Jersey Real Estate Salesperson exam. Everything you need is just a click away, with the link right down in the description. Check it out and start studying smarter, not harder, as exam day approaches. Alright, let's get started. Question 1. A seller in Hoboken removes the dining room chandelier the day before closing, replaces it with a bare ceiling socket, and tells the buyer the fixture was personal property. Which of the following item is best classified as real property unless the contract states otherwise? Your options are: A. Furniture sitting in the living room. B. An area rug placed over hardwood. C. A wired ceiling chandelier. D. A freestanding refrigerator. Which one is it? Pause the video if you need more time. The correct answer is C. A wired ceiling chandelier. C is correct because a chandelier wired into the ceiling box meets the tests of attachment and adaptation. It has been installed in a way that makes it part of the home. Removal damages the structure, so it passes with the real property. A is wrong because furniture sitting in the living room is unattached personal property. The seller can lift it and carry it out without altering the dwelling, which keeps it outside any reasonable definition of a fixture. B is wrong because an area rug rests on the floor without permanent attachment to the structure. It moves between homes the way any household item does, and nothing about its placement converts it into part of the realty. D is wrong because a freestanding refrigerator plugs into a standard outlet and rolls out on its own wheels. The connection is temporary by design, so the appliance stays chattel unless the bill of sale explicitly transfers it. A chandelier bought at a store is personal property, but bolted into the ceiling and wire it into the house, and the law calls it something new: a fixture. That single shift from movable object to part of the realty is the concept exam questions keep circling back to. Real property is the land and everything permanently attached to it. Personal property is everything else, the movable goods an owner takes from home to home. A fixture is the special case, an item that began as personal property but became part of the real estate. Courts sought hard cases with 3 signals. Attachment asks whether removing the item would damage the structure. Adaptation asks whether it was custom fitted to the property. Intention, judged by objective signs, asks whether the installer clearly meant it to stay permanently. And intention usually decides the close cases. The chandelier is wired into an electrical box. Pulling it out leaves exposed wiring and a hole in the ceiling. Contrast the freestanding refrigerator that simply rolls out and unplugs, or the rug lying on the floor. Those items announce their own impermanence. A trade fixture installed by a commercial tenant can revert to personal property at lease end. Proving attachment alone never settles ownership. The safest fix is always the contract. Name disputed items as included or excluded before the buyer ever sees the listing. Master attachment, adaptation, and intent and fixture questions stop being guesswork. Question 2. A New Jersey broker who handles property management funds for owners and tenants must maintain a dedicated trust account that is separate from the broker's operating accounts. Which administrative code chapter best imposes the trust account requirements on brokers in New Jersey? Your options are: A. NJRE 11155, Trust Accounting Rules. B. NJRE 713, Flood Hazard Areas. C. NJRE 520, Uniform Construction Code. D. NJRE 7.17 radon. Take a second. Which answer would you pick? The correct answer is A. NJRE 1155 Trust Accounting Rules. A is correct because trust accounting rules for real estate brokers in New Jersey live in NJRE 1155. The rules cover what must be deposited, how funds are accounted for, record-keeping requirements, and the Commission's audit and inspection authority. B is wrong because NJRE 713 contains the DEP's flood hazard area control regulations. It is an environmental rule and does not address broker trust accounting standards or property management funds held in escrow for owners. C is wrong because NJRE 523 contains the Uniform Construction Code adopted by the Department of Community Affairs. It governs construction, permitting, and inspections, not the broker trust accounting framework brokers must follow. D is wrong because NJRE 72827 contains the radon in residential real estate disclosure regulations. It addresses a specific environmental disclosure obligation in residential sales, not the general broker trust accounting framework imposed on real estate brokers across the state. Every dollar a broker holds that belongs to someone else sits at the center of the trust accounting rules. Those rules exist to defeat an old temptation, a broker short on cash borrowing from client money, meaning to put it back. That mixing of funds is called commingling, and it's one of the fastest ways to lose a license. In New Jersey, this lives in the Administrative Code at NJRE 11.5-5. It specifies what must be deposited and how quickly, how the account must be titled, what records the broker must keep, and the Commission's authority to audit those records. A broker of record carries personal responsibility even when a bookkeeper handles daily entries. The mechanism is simple once the purpose is clear. Client and customer money goes into a dedicated trust account, while the broker's own money, commissions, office rent, payroll, flows through a separate operating account, and the two never mix. The exam presses hardest on this gap. Commingling does not require theft. A broker who lets an earned commission sit too long in trust has commingled, and so has a broker who deposits a client's check into the operating account, even by accident. The rule is strict on purpose, because the subject is money handling, not property condition like flood hazards or radon. The Commission can inspect trust records anytime, and a shortfall is treated as a serious offense. Keeping client funds walled off, documented, and reconciled isn't a technicality. It's the core of what it means to be trusted with other people's money. Question 3. A New Jersey residential contract contains a clause stating that if the buyer defaults, the seller may retain the earnest money deposit as the seller's sole remedy and as a reasonable forecast of harm. Which of the following best identifies this clause? Your options are A. A specific performance clause, B. A subordination clause, C. A liquidated damages clause, D. A defeasance clause. Before I reveal it, which one do you think is right? The correct answer is C. A liquidated damages clause. C is correct because a liquidated damages clause sets a pre-agreed money amount as the remedy for breach when actual damages would be difficult to calculate. The earnest money deposit often serves this role in residential real estate contracts in New Jersey. A is wrong because a specific performance clause would let a party compel performance of the contract rather than collect a money remedy. The clause described here gives only the deposit as a remedy and is not an order to perform. B is wrong because a subordination clause affects lien priority between mortgages by demoting one lien below another. It has no role in a buyer's earnest money deposit remedy provision in a residential purchase contract. D is wrong because a defeasance clause appears in mortgages and obligates the lender to release the lien when the debt is paid. It has nothing to do with allocating remedies between a buyer and seller in a residential sales contract. A liquidated damages clause is an agreement made in advance that fixes the exact sum one party collects if the other breaks the contract. In a home sale, that clause usually points straight at the buyer's earnest money deposit. This exists because some breaches cause real harm that's genuinely hard to measure. When a buyer walks away, the seller suffers lost time, lost buyers, and carrying costs, but proving that dollar figure in court is slow and uncertain. So the parties simply agree on a number while they're still on good terms. For the clause to hold up, the pre-agreed amount has to be a reasonable estimate of anticipated harm, not a penalty. If it's wildly out of proportion, meant just to frighten someone into performing, a court may strike it down as an unlawful penalty. The exam trap is a crowd of clauses that sound like remedies. Specific performance forces the sale to close instead of taking money. Subordination reorders lien priority. Defeasance releases the lender's lien once the loan is paid. Sort each clause by what it's actually for, and you rarely miss these. When a buyer defaults, the seller doesn't have to prove damages in court. The contract already fixed the number. That's why the earnest money deposit, sitting in escrow from day one, is the natural vehicle for liquidated damages. Question 4. A non-resident seller of New Jersey real property closing in 2026 must address state gross income tax compliance at closing through a specific NJ division of taxation form series. Which form series best identifies the relevant non-resident sale tax compliance documents? Your options are A. The Form 1040 Federal Return, B. The IRS Schedule E, C. The Federal FIRPTA Waiver, D. The GIT series of forms. What's your answer? Commit to one before I continue. The correct answer is D. The GIT and REP series of forms. D is correct because the GIT and REP series of forms governs gross income tax compliance for sellers of New Jersey real property at closing. The forms determine whether a non-resident seller must remit estimated tax at closing or qualifies for an exemption. A is wrong because the Form 1040 Federal Return is the U.S. individual income tax return. It is not a New Jersey closing compliance form for non-resident real property sales. That role belongs to the state's GIT and REP series. B is wrong because the IRS Schedule E reports rental income and expenses on a federal tax return. It is unrelated to non-resident state tax compliance for the sale of New Jersey real property at closing. C is wrong because the federal FIRPTA waiver is part of the Federal Foreign Investment in Real Property Tax Act, withholding regime for sales by foreign sellers. It is a federal mechanism distinct from New Jersey's state GIT and REP framework. At a New Jersey closing with an out-of-state seller, the deed can't be recorded without the right GIT and REP form. This series of state forms exists to guarantee that New Jersey collects its gross income tax on the sale before the seller and the money leave the state. A resident seller stays reachable after closing, but a non-resident can take the proceeds and vanish across a state line. So New Jersey collects its tax at the one moment it still holds control, the recording of the deed. The mechanism runs through a small family of forms. GIT and REP 1 is used when a non-resident seller must make an estimated tax payment at closing. GIT and REP 3 is signed by a resident seller certifying residency to claim exemption from that withholding. The classic error is confusing this with FIRPTA, the federal regime targeting foreign sellers through the IRS. GIT and REP is purely a state mechanism aimed at non-residents, and a U.S. citizen who lives out of state still triggers it. The tell is the phrase New Jersey gross income tax. The closing form is a prepayment, reconciled later on the seller's non-resident return. New Jersey captures the estimated tax at the recording counter because chasing a seller who's already moved on rarely works. Question 5. A New Jersey brokerage firm operating from a main office in Newark wants to open a branch office in Cherry Hill. Which of the following best describes a key requirement for the branch office under the License Act and Commission rules? Your options are: A. Each branch needs on-site management oversight. B. Branch offices need no separate oversight. C. Branch offices need not display license. D. Branch offices share license number freely. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. Each branch needs on-site management oversight. A is correct because each branch office must have on-site management oversight by a designated broker or broker salesperson responsible for supervision of activity at that location. The branch must also display the firm's license and meet other commission requirements. B is wrong because branch offices need on-site management oversight. They are not unsupervised satellites under the License Act. The broker of record and the assigned branch manager bear responsibility for licensee conduct at the branch. C is wrong because branch officers must display the firm's license and broker information at the office under commission rules. Displaying the license is a basic compliance requirement under the License Act and NJRE 11.5. D is wrong because branch officers operate under the firm's license but with proper registration as a branch. They cannot freely share a license number without registering the branch with the commission and meeting branch requirements. The word branch sounds like something smaller, a satellite running loosely on its own. But New Jersey license law treats a branch office as the opposite, a place where supervision must follow, not fade away. A branch must be registered with the commission, and it must have a designated broker or broker salesperson physically supervising activity on site, displaying the firm's license just like the main office. Forgetting either half misses what the statute demands. Picture the accountability as a chain. The broker of record oversees the whole firm. A designated manager oversees each branch, and salespersons work under that manager. The manager answers upward to the broker of record, who answers to the commission. Think of a Newark firm opening a Cherry Hill branch an hour south. It registers the branch, posts a manager on site, and displays its license there, so a consumer walking in deals with real accountable supervision, not a distant echo of the main office. A license carries responsibility that geography cannot thin out. A properly run branch office is a full extension of the firm's accountability, never a loophole around it. Question 6. An owner of property in Camden conveys to a former co-owner whatever interest the grantor may have without warranting anything about title. The deed is often used to clear a cloud on title or to release a contingent interest. Which of the following best identifies this deed? Your options are: A. General warranty deed. B. Bargain and sale deed with covenants. C. Quitclaim deed. D. Sheriff's deed after foreclosure. Which would you go with? Lock it in before the reveal. The correct answer is C. Quitclaim deed. C is correct because a quitclaim deed conveys only whatever interest the grantor happens to hold at the time of execution and contains no warranties. It is commonly used to release contingent interest and to clear clouds on title between known parties. A is wrong because a general warranty deed warrants against all defects in title, even those arising before the grantor's ownership. It provides the strongest title protection and is the opposite of the no warranty quitclaim deed described in the question. B is wrong because a bargain and sale deed with covenants warrants that the grantor has not created or suffered encumbrances during ownership. It carries some limited covenants, which the quitclaim deed described in the question does not. D is wrong because a sheriff's deed after foreclosure is issued by a sheriff under a court-ordered sale. It is a specific judicial sale instrument, not the general clearing of title deed the question describes. Not all deeds promise the same thing. They range from the fully guaranteed general warranty deed down to the quitclaim, which promises nothing at all about title quality. The general warranty deed guarantees title against every defect, even ones predating the grantor. The bargain and sale deed with covenants only warrants against problems the grantor personally caused. The quitclaim warrants nothing, just transferring whatever interest exists. And the sheriff's deed carries the authority of a court-ordered foreclosure sale rather than any personal promise. So why would anyone accept a deed with no warranty? Because the quitclaim isn't for selling to a stranger, it's for clearing a cloud on title between people who already know the situation. Like a former co-owner releasing a leftover interest after a divorce. The exam signals are unmistakable. Phrases like, whatever interest the grantor may have, without warranting title, or to clear a cloud, all point straight to a quitclaim, while promises of the strongest possible protection point to a general warranty deed instead. A warranty deed answers how safe the title is. A quitclaim simply answers who might hold a claim and clears it away. Use it to tidy the record between known parties. Never when a buyer needs the seller to stand behind the title. Question 7. A homeowner in Camden suspects mold in her basement and asks the licensee how to handle disclosure. New Jersey treats mold disclosure as part of broader property condition disclosure, but the licensee must avoid practicing engineering or environmental science. Which of the following best describes the licensee's appropriate role? Your options are A. Promise the buyer no mold present. B. Always insist seller sand visible spots. C. Avoid mentioning mold to either party. D. Disclose known facts and recommend professionals. Don't overthink it. Which one feels right? The correct answer is D. Disclose known facts and recommend professionals. D is correct because the licensee should disclose known facts about mold accurately and recommend that the buyer obtain a qualified professional inspection or remediation. The licensee should not guarantee absence of mold or take on technical assessments outside the licensee's competence. A is wrong because promising the buyer that no mold is present misrepresents the licensee's knowledge and exposes the licensee to liability for negligent or fraudulent misrepresentation. The proper approach is honest disclosure and professional referral. B is wrong because always insisting the seller sand all visible spots is technical advice outside the licensee's competence. Mold remediation requires specialized expertise, and the licensee should refer the matter to qualified professionals rather than direct DIY treatment. C is wrong because avoiding mention of mold to either party can amount to concealment of a known condition. The licensee owes affirmative duties of disclosure when conditions are known, and the proper response is honest disclosure with referral to experts. A real estate licensee is an expert in brokerage, not in mold engineering or law. Getting mold questions right means staying inside a narrow lane, report known facts, and hand technical judgment to qualified professionals. New Jersey treats mold as part of the general duty to disclose property conditions. A licensee who knows of a material issue can't hide it. But disclosing facts is not the same as acting like an inspector or a remediation expert. The exam's tempting shortcuts each cross a line. Promising no mold exists is misrepresentation. Telling someone to scrub the spots is unqualified technical advice that can spread spores. And staying silent is concealment of a known condition. Picture the licensee walking a narrow path between two ditches. Misrepresentation on one side, concealment on the other. Staying on the path means disclosing facts and referring buyers to a mold assessor or remediation contractor. Honesty plus referral isn't the timid choice, it's the professionally correct one. Disclose everything material that you know and claim expertise in nothing that requires a different license. Question 8. After the savings and loan crisis, Congress required that appraisals for federally related transactions be performed by state-licensed or state-certified appraisers under uniform professional standards. Which federal statute best identifies this 1989 reform that created the modern appraisal regulatory framework? Your options are FIRREA, B. TILA, C. IRSPA, D. FIRPTA. Got a guess? Lock it in. The correct answer is A. FIRREA. A is correct because FIRREA, the Financial Institutions Reform, Recovery and Enforcement Act of 1989, required state licensure of appraisers and adoption of USPAP for federally related transactions. New Jersey implements those requirements through the Real Estate Appraisers Act. B is wrong because TILA is the Truth in Lending Act, which governs disclosure of credit terms to consumer borrowers. It addresses loan transparency rather than the regulation of who may appraise property in federally related transactions. C is wrong because RESPA is the Real Estate Settlement Procedures Act, which prohibits kickbacks and regulates settlement service disclosures. It controls closing practices rather than imposing licensure requirements on appraisers performing federally related work. D is wrong because FIRRTA is the Fair and Accurate Credit Transactions Act, which addresses identity theft and the disposal of consumer information. It is unrelated to the appraisal licensure regime created in the wake of the savings and loan crisis. Appraiser licensing wasn't designed in calm times, it was built from disaster. In the 1980s, hundreds of savings and loan institutions collapsed, sunk in part by inflated and corrupt appraisals backing loans on values that didn't exist. Congress responded in 1989. Before this law, anyone could appraise property for a bank loan, trained or not. FIRREA required that federally related transactions use state-licensed or state-certified appraisers following USPAP, the Uniform Standards of Professional Appraisal Practice. FIRREA created a two-layer system. Federal law sets the requirement, and each state builds the licensing and enforcement apparatus. New Jersey does this through its Real Estate Appraisers Act and a state appraiser board that issues credentials and disciplines violations. The exam trap is alphabet soup. The Truth in Lending Act covers credit disclosures. The Real Estate Settlement Procedures Act covers closing kickbacks. And the Fair and Accurate Credit Transactions Act covers identity theft. Only FIRREA created the appraisal licensure regime. Whenever an exam question mentions the savings and loan crisis, uniform appraisal standards, or state-licensed appraisers, FIRREA is the statute doing the work. Question 9. A consumer in Newark signs a residential lease that is dense, jargon-filled, and difficult to understand for an ordinary reader. A New Jersey statute requires consumer contracts to be written in clear and coherent language using ordinary words. Which statute best imposes this readability standard? Your options are A. The Realty Transfer Fee Act, B. The Anti-Eviction Act, C. The Plain Language Act, D. The Sales Full Disclosure Act. Which one is it? Pause the video if you need more time. The correct answer is C. The Plain Language Act. C is correct because the New Jersey Plain Language Act, NJSA 561218 Circular, requires consumer contracts to use simple, clear, and coherent language with ordinary words and limited cross-references. A non-conforming contract may be unenforceable to that extent. A is wrong because the Realty Transfer Fee Act imposes a fee on the recording of deeds at closing. It is a revenue statute and has no role in regulating the readability or language style of consumer contracts in New Jersey. B is wrong because the Anti-Eviction Act enumerates grounds for evicting residential tenants and procedural requirements. It addresses substantive eviction rules, not the linguistic clarity of the underlying lease the parties signed. D is wrong because the Sales Full Disclosure Act regulates registrations for large subdivisions and out-of-state offerings. It is a security-style disclosure statute, not a general regulation of the readability of all consumer contracts in New Jersey. A contract nobody can read is a contract that hides its own terms. New Jersey's Plain Language Act exists to fix exactly that problem in consumer contracts. The core issue is a mismatch of power and information. The landlord, lender, or seller has lawyers and experience, while the consumer has neither. Consent to terms you cannot understand is not meaningful consent. The standard is concrete. Sentences should be reasonably short. Everyday words should replace legal jargon, and confusing cross-references should be limited. A contract that violates the standard can be found unenforceable, and a consumer may recover actual damages. Keep this separate from other New Jersey statutes. The Realty Transfer Fee Act is about recording fees. The Anti-Eviction Act governs eviction grounds, and the Sales Full Disclosure Act regulates subdivision registration. Only the Plain Language Act targets how the contract itself is written. The law shifts the risk of confusion onto the drafter. Write the contract so the consumer can understand it, or lose the benefit of the parts that fail. When an exam describes a dense, jargon-filled consumer contract, the Plain Language Act is the statute in play. Question 10. An instructor preparing students for the New Jersey Salesperson exam reviews the 4 government powers that limit private ownership, captured by the mnemonic Pete. Which of the following is the correct expansion of Pete in the order it represents the 4 powers? Your options are A. Possession, eminent domain, taxation, enjoyment. B. Police power, easement, title, escheat. C. Police power, enjoyment, title, eviction. D. Police, eminent domain, taxation, escheat. Take a second. Which answer would you pick? The correct answer is D. Police, eminent domain, taxation, escheat. D is correct because Pete stands for police power, eminent domain, taxation, and escheat. These are the 4 constitutional powers government exercises over privately owned real property, and the salesperson exam routinely tests recognition of each by description and by name. A is wrong because possession and enjoyment are sticks in the private owner's bundle of rights, not government powers. 2 of the letters mislabel private interests as state powers, which fails the basic test of the Piet mnemonic. B is wrong because easement and title are private interests rather than powers held by government. Pete refers to the public side limits on ownership, so listing easement and title for those powers misidentifies what the acronym tracks. C is wrong because enjoyment, title, and eviction are not government powers in the PT framework. The acronym names broad constitutional authorities, and 3 of these letters point to ordinary aspects of private ownership or possession. Private land ownership in the U.S. is powerful but never absolute. Above every parcel sit 4 governmental powers that can override the owner's wishes, remembered by the mnemonic Pete: police power, eminent domain, taxation, and escheat. These powers exist because private ownership and public life have to coexist. If an owner could ignore safety, refuse taxes, or block every public need, organized society would break down. So the state keeps these 4 tools in reserve. Police power lets government regulate land use through zoning and building codes. Eminent domain takes property for public use with just compensation. Taxation funds public services through property taxes. And escheat returns property to the state when an owner dies with no will and no heirs. Students often blur police power with eminent domain. Police power restricts how land is used and pays the owner nothing, since they still own the land. Eminent domain actually takes the land or part of it and requires just compensation. Every stick in the ownership bundle, possession, enjoyment, easements, and title exists beneath these four public powers. Knowing what each one does and how it differs from private rights is the real understanding behind the acronym. Question 11. A licensee in Edison is first about to discuss a specific property with a walk-in consumer at an open house. Under New Jersey rules, the licensee must present the consumer information statement at this first substantive contact. Which of the following best identifies the consequence of missing this timing? Your options are A. Disciplinary action by the Real Estate Commission. B. Automatic forfeiture of any later commission. C. Cancellation of any sale contract that follows. D. Loss of state appraiser certification. Before I reveal it, which one do you think is right? The correct answer is A. Disciplinary action by the Real Estate Commission. A is correct because failure to provide the CIS at the first substantive contact about a specific property exposes the licensee to disciplinary action by the New Jersey Real Estate Commission. The CIS is mandated by NJRE 11056.9 and is a core compliance requirement. B is wrong because automatic forfeiture of any later commission is not the regulatory consequence. The NJRE may discipline the licensee and the broker of record, but the licensee's commission entitlement is a separate matter under the listing agreement. C is wrong because cancellation of the resulting sale contract is not the consequence. The contract between buyer and seller does not become void because the licensee failed the agency disclosure step. The licensee's discipline is the regulatory consequence. D is wrong because loss of state appraiser certification has no relation to this failure. Appraiser certification is administered by the Real Estate Appraiser Board, not the Real Estate Commission, and the CIS is unrelated to appraisal credentialing. Getting agency disclosure timing wrong does not void a contract or erase a commission. It triggers discipline against the license itself, and that distinction is the whole point of this topic. New Jersey requires licensees to deliver the consumer information statement at first substantive contact about a specific property. The CIS explains the relationships a consumer can have with a brokerage, seller's agent, buyer's agent, disclosed dual agent, and transaction broker or customer. Delivering it early protects consumers from confiding in someone who actually represents the other side. The mechanism is a matter of sequence. First substantive contact is the trigger, meaning the first real discussion about a particular property. At that exact point, before the substance continues, the CIS goes into the consumer's hands. Several plausible consequences simply do not happen here. The commission stands under the listing agreement. The sale contract stands on its own, and appraiser certification lives under a completely different board. The real exposure is narrow. The Real Estate Commission disciplines the licensee. A licensee can fully earn a commission and still face commission sanction for a disclosure failure in the same transaction. Attach the right consequence to the right failure, and you'll separate real understanding from guessing among penalties that merely sound serious. Question 12. New Jersey law requires periodic inspection of certain rental dwellings for lead-based paint hazards, with frequency tied to whether the property is in a Tier 1 or Tier 2 municipality based on historical lead test data. Which of the following best identifies what this 2021 state law primarily targets? Your options are A. Owner-occupied single-family homes, B. Pre-1978 residential rental units, C. Newly constructed condominiums, D. Industrial commercial buildings. What's your answer? Commit to one before I continue. The correct answer is B. PRA 978 residential rental units. B is correct because the New Jersey lead-based paint inspection law for rentals targets pre-1978 residential rental units, requiring inspections during turnover or every 3 years, with municipality tiering based on lead poisoning incidence data and historical testing results. It is wrong because owner-occupied single-family homes are not the target of the New Jersey rental lead inspection law. The statute focuses on rental units where tenants, and especially children, may be at risk from existing lead-based paint hazards. C is wrong because newly constructed condominiums built after 1978 are unlikely to contain lead-based paint and are not the target of the law. The statute is built around older housing stock that predates the federal 1978 ban on residential lead paint. D is wrong because industrial commercial buildings are not within the scope of the New Jersey rental lead inspection law. The statute is a residential rental protection law focused on dwellings occupied by tenants and their families. Lead paint was banned for residential use in the United States in 1978, but millions of older rental units still carry it on walls, trim, and windows. New Jersey's 2021 rental lead inspection law targets exactly that surviving hazard. The age cutoff is the entire logic of the statute. Units built before the ban are presumed at risk, so the law reaches them, while newer housing is left alone. It is not about owner-occupied homes, where the owner chooses the risk, and not about commercial buildings where children don't live. Inspections happen on tenant turnover or on a periodic cycle, generally every 3 years, and municipalities are sorted into tiers based on their history of lead poisoning and prior testing. Tier 1 municipalities with higher recorded risk face more frequent scrutiny than Tier 2. The federal disclosure rule only obligates a landlord to reveal known hazards and hand over a pamphlet, a paperwork duty. New Jersey's law goes further, forcing actual inspection on a schedule, and treats it as a mandate with teeth, not a suggestion. Before 1978 means presumed lead risk, and rental occupancy means vulnerable tenants who didn't create the hazard. Put those together, and the law's reach makes sense. Older rental units, inspected on a schedule tuned to local risk. Question 13. An appraiser values a Hoboken row house by adjusting recent sale prices of similar nearby homes upward or downward for differences in features, condition, and date of sale. Which of the 3 approaches to value is the appraiser primarily applying? Your options are A. Income approach, B. Reconciliation method, C. Sales comparison approach, D. Cost approach. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. Sales comparison approach. C is correct because the sales comparison approach develops a value indication by analyzing recent sales of similar nearby properties and adjusting for differences. It is the dominant approach for residential property and rests on the principle of substitution. A is wrong because the income approach converts the future income of a property into a present value using a capitalization rate or discount rate. It is the primary approach for income-producing property, not for an owner-occupied row house. B is wrong because reconciliation is the step where the appraiser weighs the indications from the 3 approaches and arrives at the final opinion. It is not itself an approach to value. It is the analytical step that follows the approaches. D is wrong because the cost approach estimates value by calculating land value plus the depreciated cost of the improvements. It is most useful for special use property and new construction, not for a typical row house transaction with abundant sales data. The sales comparison approach values a property by looking at what buyers recently paid for similar properties nearby, then adjusting for the differences, It mirrors exactly how an ordinary buyer thinks about a purchase. The principle underneath is substitution. A buyer will not pay more for a property than the cost of an equally desirable alternative. If comparable houses sold in a narrow range, the subject property is worth about the same. The mechanism runs through adjustments, and the direction is what students often reverse. The appraiser always adjusts the comparable, never the subject. Subtract value when the comparable has a feature the subject lacks. Add value when it's missing one, and correct for the date of sale. This approach dominates residential work because ordinary houses sell often, giving appraisers abundant comparables. That same scarcity of comparables is why it's weak for unusual properties. The income approach fits rental property, the cost approach fits new or special purpose buildings, and sales comparison is the workhorse for houses that trade frequently. The appraiser doesn't invent worth, they read it from what real buyers recently paid for real substitutes, correcting for the differences. When property trades often, that reading is the most persuasive evidence of value there is. Question 14. An out-of-state developer wants to market a 50-lot subdivision in Florida to New Jersey residents through display advertising and mailings. New Jersey law requires registration of the offering before any solicitation. Which statute best imposes this requirement on the developer? Your options are A. The Plain Language Act, B. The Truth in Renting Act, C. The Realty Transfer Fee Act, D. NJ Sales Full Disclosure Act. Which would you go with? Lock it in before the reveal. The correct answer is D. NJ Sales Full Disclosure Act. D is correct because the Real Estate Sales Full Disclosure Act, NJRE, quantifarm kikans amsis bevinset etsuku requires registration with the New Jersey Real Estate Commission before the offer or sale of subdivision. Interest is marketed to New Jersey residents from out of state. A is wrong because the Plain Language Act addresses the clarity and readability of consumer contracts. It does not require registration of subdivision offerings sold to New Jersey residents by out-of-state developers. B is wrong because the Truth in Renting Act requires landlords of certain residential properties to provide tenants with statutory information about rights. It is a landlord-tenant disclosure statute, not a subdivision offering registration statute. C is wrong because the Realty Transfer Fee Act imposes a fee on the recording of deeds at closing. It is a revenue statute and not the registration framework that controls out-of-state subdivision sales offerings. Selling distant land sight unseen is one of the oldest tricks in real estate fraud. New Jersey's Sales Full Disclosure Act exists to stop out-of-state developers from marketing subdivided land to New Jersey residents before the facts are on the table. A buyer purchasing a local home can inspect it, walk the neighborhood, and check the records. A New Jersey resident tempted by a Florida subdivision through a mailer has none of that, so the law steps in to close the gap. The mechanism is registration before solicitation. The developer must file with the New Jersey Real Estate Commission and provide a disclosure document before advertising ever reaches a New Jersey resident, and marketing that jumps ahead of registration is itself the violation. Only the Sales Full Disclosure Act reaches an out-of-state developer marketing subdivided land into New Jersey. The Plain Language Act governs contract wording. The Truth in Renting Act covers landlord-tenant disclosures, and the Realty Transfer Fee Act taxes recorded deeds. The statute protects New Jersey residents at the moment of solicitation before money changes hands, conditioning the right to solicit on registration and disclosure. Whenever out-of-state subdivided land is marketed into New Jersey, this is the framework doing the work. Question 15. A landlord in Newark wants to evict a residential tenant for one specific cause. New Jersey law restricts residential evictions to grounds enumerated by statute, with notice and process specified for each. Which statute best contains that enumerated list of grounds for removal in covered residential tenancies? Your options are A. The NJ Anti-Eviction Act, B. The NJ Consumer Fraud Act, C. The Real Estate Sales Full Disclosure Act, D. The Truth in Renting Act. Don't overthink it, which one feels right? The correct answer is A. The NJ Anti-Eviction Act. A is correct because the Anti-Eviction Act, NJSA 2D18-61.1 enumerates the only grounds on which a covered residential tenant may be removed. Lettered A through R plus added grounds. The statute requires specific notices key to each ground. B is wrong because the Consumer Fraud Act addresses unconscionable commercial practices, misrepresentations, and certain home improvement contracts. It does not list grounds for residential eviction or set notice requirements for landlord-tenant cases. C is wrong because the Real Estate Sales Full Disclosure Act regulates registrations for large subdivisions and out-of-state offerings. It deals with consumer protection in real estate sales offerings, not the grounds for evicting a residential tenant. D is wrong because the Truth in Renting Act requires landlords of certain residential properties to distribute information about tenant rights. It does not enumerate the grounds for eviction. That role belongs to the Anti-Eviction Act. New Jersey took an unusual stance on residential tenancy. A covered tenant generally cannot be evicted unless the landlord proves a specific statutory ground. There's no automatic right to remove a tenant just because the lease term expired. This exists to protect residential stability. Before such protections, a tenant who did nothing wrong could be turned out at the landlord's whim, enabling retaliation against tenants who complained about conditions. The mechanism is a closed list of grounds paired with required notices, running from non-payment of rent through disorderly conduct, property damage, and violation of reasonable lease rules. Each ground carries its own procedural demands, and picking the wrong one or skipping the notice can sink the case regardless of the facts. Here's the inversion that matters most. A landlord might assume that when a lease term ends, possession simply returns. But for covered residential tenancies in New Jersey, expiration of the term alone is not a ground for eviction. The tenant may stay, and the landlord still needs statutory cause. Other laws like the Consumer Fraud Act, the Sales Full Disclosure Act, and the Truth in Renting Act touch tenants, but never list eviction grounds. Only the Anti-Eviction Act does, and when a stem needs a specific enumerated ground, that's your source. Question 16. A federally chartered enterprise buys conforming residential mortgages from primary lenders and pools them into mortgage-backed securities sold to investors. It does not lend directly to consumers. Which of the following best identifies the role of Fannie Mae in the mortgage market? Your options are a primary market direct lender, B, a secondary market participant, C, a federal banking regulator, D, a title insurance underwriter. Got a guess? Lock it in. The correct answer is B, a secondary market participant. B is correct because Fannie Mae is a government-sponsored enterprise that operates in the secondary mortgage market. It buys conforming loans from primary lenders, pools them into mortgage-backed securities, and sells those securities to investors, providing liquidity to lenders. A is wrong because Fannie Mae does not originate mortgages directly to consumers. Its function is to buy loans from primary lenders after origination, which is the defining activity of the secondary market rather than the primary market. C is wrong because Fannie Mae is not a banking regulator. Its regulator is the Federal Housing Finance Agency. Fannie Mae itself is a market participant that purchases loans and issues securities rather than supervising other lenders. D is wrong because title insurance underwriters issue title policies protecting owners and lenders against title defects. Fannie Mae has nothing to do with title insurance. It operates in the mortgage funding chain rather than the title insurance industry. Fannie Mae does not lend money to home buyers. Understanding that single fact unlocks almost everything the exam asks about the secondary mortgage market. The primary market is where loans are originated to borrowers. The secondary market is where existing loans are bought, sold, and packaged. Fannie Mae operates one step removed from consumers in the secondary market. The secondary market exists to solve a liquidity problem. A lender's cash would stay tied up for 30 years. But when Fannie Mae buys the loan, that lender gets its money back immediately and can lend again. The mechanism is purchase, pooling, and securitization. Fannie Mae buys conforming loans from primary lenders, pools them together, and issues mortgage-backed securities to investors, while homeowners' payments flow through the pool to those investors. Fannie Mae is a conduit between local lending and global capital. It doesn't compete with the corner bank for a borrower's business. It funds that bank by buying what it originates, keeping new mortgage money flowing. Question 17. A New Jersey property manager in Cherry Hill orders a routine credit and background check on a rental applicant. The Federal Fair Credit Reporting Act requires the manager to obtain the applicant's specific authorization before pulling the report. Which of the following best identifies the form of authorization typically required? Your options are A. A verbal yes at the property tour. B. A handwritten note from the applicant's relative. C. A signed written authorization from the applicant. D. A landlord-only internal memo. Which one is it? Pause the video if you need more time. The correct answer is C. A signed written authorization from the applicant. C is correct because the Federal Fair Credit Reporting Act generally requires a clear and conspicuous written disclosure and the applicant's signed written authorization before pulling a consumer report. The Act also imposes adverse action notice duties when reports support denial. A is wrong because a verbal yes at the property tour does not satisfy the FCRA's written authorization requirement. The Act specifically calls for a written disclosure and signed permission before pulling a consumer report on an applicant. B is wrong because a handwritten note from the applicant's relative cannot substitute for the applicant's own signed authorization. The FCRA requires permission from the consumer whose report will be pulled, not from a third party. D is wrong because a landlord-only internal memo is not a permission from the applicant and does not satisfy the FCRA. The Act requires written disclosure to the consumer and the consumer's signed authorization, not internal landlord paperwork. Before a property manager can pull anyone's credit or background report, federal law demands permission in one specific form. The Fair Credit Reporting Act requires a clear written disclosure and the applicant's signed written authorization before the report can ever be obtained. The law insists on a signature because of what's inside these reports: credit history, payment records, and background information that can determine whether someone gets housing, a job, or a loan. Congress decided information this consequential requires informed, documented consent, not a casual say-so. The mechanism has two linked pieces. First, a clear written disclosure telling the applicant a report may be obtained. Second, the applicant's own signed authorization granting permission. If the report leads to a denial, the law adds one more duty, an adverse action notice. A spoken yes during a tour, a note from a relative, or an internal landlord memo all fail the standard. Only the applicant's own signed written authorization satisfies the statute. Anything looser leaves the manager exposed to liability. The paperwork isn't bureaucratic clutter, it's the manager's shield. Whenever a scenario describes pulling a credit or background check, the law expects one thing: a signed writing from the applicant. Question 18. A New Jersey licensee shows a property to a buyer customer who has chosen not to be represented. The licensee gives the buyer the CIS and discusses the available business relationships. Which document should the licensee also keep on file to document the buyer's representation choice? Your options are A. An MLS listing summary printout, B. A buyer brokerage commission schedule, C. A title insurance commitment, D. A signed declaration of choice or acknowledgement. Take a second. Which answer would you pick? The correct answer is D. A signed declaration of choice or acknowledgement. D is correct because good practice and commission guidance call for the licensee to obtain a signed declaration of business relationship choice or an acknowledgement of receipt of the CIS, documenting how the consumer is choosing to be treated. A is wrong because an MLS listing summary printout is a marketing document for a specific property. It does not establish or memorialize the consumer's business relationship choice, which is a separate compliance matter at first substantive contact. B is wrong because a buyer brokerage commission schedule sets a representation fee for a buyer client. The question concerns an unrepresented customer. A commission schedule does not document the consumer's choice to be a customer rather than a client. C is wrong because a title insurance commitment is issued by a title insurance company and identifies title status. It is unrelated to documenting a consumer's choice of business relationship with the real estate licensee at first substantive contact. Explaining representation options is only half the job. The other half is proving later that the conversation happened and what the consumer decided. Business relationship choices are consequential and disputes are common. If a disagreement arises later about whether someone was a client or a customer, memory and good intentions are weak evidence, but a signed document made at the time settles the question. The mechanism is documentation of consent. After presenting the consumer information statement and discussing the options, the licensee gets a signed declaration of the chosen relationship, or an acknowledgement of receipt placed in the file. The signature doesn't create the relationship, it simply proves what was disclosed and decided. The exam tests whether you can separate this compliance record from other paperwork. A listing summary describes a property. A commission schedule sets a fee for a represented buyer, and a title commitment reports on title. Only the signed acknowledgement documents the consumer's relationship choice. Explaining the option satisfies the consumer's right to know. Capturing the signature satisfies the licensee's need to prove it, protecting everyone if anyone ever asked what was told and what was chosen. Question 19. Congress passed the Fair Housing Act of 1968 to address discrimination in residential transactions on the basis of certain protected classes. Several amendments later expanded the list. Which of the following best identifies the full set of currently protected classes under the Federal Fair Housing Act? Your options are A. Race, color, religion, sex, disability. B. Race only with no additional protections. C. Race and color only. D. Age, income, marital status only. Before I reveal it, which one do you think is right? The correct answer is A. Race, color, religion, sex, disability. A is correct because the Fair Housing Act of 1968 originally covered race, color, religion, and national origin. The 1984 amendments added sex, and the 1988 amendments added disability and familial status, with sexual orientation reached through the 2021 HUD memo. B is wrong because race only is the scope of the Civil Rights Act of 1866, not the Fair Housing Act of 1968. The The 1866 Act focuses on race with no exemptions, while the 1968 Act covers a broader list of protected classes. C is wrong because race and color only understates the full Fair Housing Act protected class list. The 1968 Act and its amendments cover additional bases including religion, national origin, sex, disability, and familial status. D is wrong because age, income, and marital status are not federally protected classes under the Fair Housing Act. Some states like New Jersey add additional protections under their own laws, but the federal list is the one the question asks about. The Fair Housing Act of 1968 didn't arrive all at once with its full list of protections. It grew in layers, and the exam rewards knowing exactly how that list expanded over time. The original statute prohibited discrimination based on race, color, religion, and national origin. These were the categories most visibly used to shut families out of neighborhoods, and they formed the core of the law. The 1974 amendments added sex. The 1988 Fair Housing Amendments Act added disability and familial status, protecting families with children and pregnant women. Then in 2021, a federal directive read the Act's sex protection to also cover sexual orientation and gender identity. Here's the practical point. The federal law is a floor, not a ceiling. New Jersey's own law against discrimination protects additional classes beyond the federal set. So a licensee there answers to a broader list than the federal act alone. Learn the Fair Housing Act as a timeline. The original 4 classes, then sex, then disability and familial status, then the modern reading covering sexual orientation. Understood that way, the list becomes something you reason through, not just memorize. Question 20. A real estate wholesaler in New Jersey contracts to buy a residential property and then assigns the contract to an end buyer for a fee, without ever taking title. Recent amendments to New Jersey law restrict this activity and may require licensure. Which agency primarily enforces these wholesaling restrictions? Your options are A. FinCEN, B. the New Jersey Real Estate Commission, C. the Federal Reserve Board, D. Department of Housing and Urban Development. What's your answer? Commit to one before I continue. The correct answer is B. the New Jersey Real Estate Commission. B is correct because the New Jersey Real Estate Commission enforces real estate licensing and brokerage rules, including the recent wholesaling amendments that restrict unlicensed assignment fee transactions in residential property. Wholesaling without a license can trigger discipline and civil penalties. A is wrong because FinCEN focuses on anti-money laundering reporting and financial crime enforcement under the Bank Secrecy Act. It does not regulate real estate licensure or enforce New Jersey wholesaling restrictions on assignment fee transactions. C is wrong because the Federal Reserve Board sets monetary policy and supervises certain banks. It is not the enforcement agency for New Jersey real estate licensure or wholesaling restrictions on residential property assignments. D is wrong because the U.S. Department of Housing and Urban Development administers GIT programs and federal fair housing law. It does not enforce New Jersey real estate licensure or wholesaling restrictions, which are state regulatory matters. Wholesaling looks a lot like brokering, contracting to buy property, then assigning that contract to an end buyer for a fee, often without ever taking title. Because it resembles brokerage so closely, New Jersey brought it under the same regulatory roof. The tempting wrong answers are all real federal agencies governing something else entirely. A financial crimes network focused on money laundering, the central bank setting monetary policy, and a housing department administering fair housing and loan programs. None of them touches New Jersey's rules on who may broker or wholesale property in the state. A wholesaler contracts to buy a property. then assigns that contract to an end buyer for a fee, profiting from the spread without ever taking title. That's close enough to bringing buyers and sellers together for compensation that the Commission treats it as brokerage adjacent activity requiring the same oversight. Calling yourself a wholesaler instead of a broker doesn't move the activity outside the Commission's reach. The Commission applies its existing licensing and discipline structure, cease and desist orders, civil penalties, and legal referral to unlicensed wholesaling just as it would to unlicensed brokerage. Whenever a question asks who enforces a real estate licensing or brokerage restriction in New Jersey, the answer is the State Real Estate Commission, the body that follows what you do, not what you call it. Question 21. A New Jersey listing agent receives multiple offers for the same property over a single weekend. The seller wants to consider each offer in private and respond as the seller chooses. Which of the following best identifies what the listing agent must do with each offer received? Your options are A. Reject the lowest offer without seller review. B. Accept only the highest offer received. C. Present each offer promptly to the seller. D. Hold offers for 1 week before presenting. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. Present each offer promptly to the seller. C is correct because a licensee must present all offers promptly to the seller client unless the seller has expressly directed otherwise in writing. The seller has the right to evaluate every offer and decide how to respond, not the agent. A is wrong because rejecting the lowest offer without seller review usurps the seller's decision authority. The licensee must present the offer and let the seller decide whether to reject it, regardless of how low the price appears. B is wrong because accepting only the highest offer received deprives the seller of the right to evaluate terms beyond price. The licensee must present each offer. The seller is the only one who can decide which offer to accept. D is wrong because holding offers for 1 week before presenting violates the duty to present promptly. The seller may lose opportunities and the licensee may breach the duty of obedience and reasonable care by stockpiling offers. The decision to accept, reject, or counter an offer belongs to the seller, not the agent. That single fact is the root of every rule about presenting offers. The rule flows from 3 fiduciary duties: obedience, loyalty, and disclosure. An offer is material information, so withholding or delaying it breaches all 3 at once. The mechanism is strict. Every offer goes straight to the seller, unless the seller has given written instructions otherwise. The agent's job is to convey and advise, never to filter. Exam questions test tempting shortcuts: rejecting the lowest offer unseen, accepting only the highest bid, holding offers back to let more accumulate, or screening offers before the seller sees them. Each one quietly steals the seller's decision. Presenting a weak offer isn't a failure, it's the fulfillment of duty. The agent carries every offer to the seller, and the seller alone decides its fate. Question 22. An appraiser in Princeton notes that a smaller and less expensive home located in a neighborhood of larger and more expensive homes often shows a higher per square foot value than identical houses in a more uniform tract. Which principle of value best captures this lift? Your options are A. Substitution, B. Anticipation, C. Highest and best use, D. Progression. Which would you go with? Lock it in before the reveal. The correct answer is D. Progression. D is correct because progression holds that the value of a lesser quality property tends to be lifted by association with surrounding higher value properties. Regression is the opposite effect, where a higher quality property is dragged down by association with surrounding lower value properties. A is wrong because substitution caps the price a buyer will pay based on the cost of an equally desirable alternative. It does not explain the lift a smaller home receives from being located in a neighborhood of more expensive homes. B is wrong because anticipation explains why future benefits drive present value. It is the principle behind the income approach and is not the principle that captures the lift a smaller home enjoys from its surroundings. C is wrong because highest and best use evaluates the optimal use of a parcel under tests of legality, physical possibility, financial feasibility, and maximal productivity. It is an analytical framework for use, not a comment on neighborhood-driven value lift. A modest cottage on a street of mansions sells for more per square foot than an identical cottage in a tract of lookalikes. That surprising lift is called progression, and it has a mirror image called regression. Value is relational, not just physical. Buyers pay for the location and setting as well as the structure, so desirable surroundings pull a modest property's price upward, while inferior surroundings drag a superior property's price downward. Progression is the upward pull a lesser home gets from richer neighbors. Regression is the downward drag a superior home suffers among cheaper ones. Don't confuse either with substitution, which just sets a price ceiling based on equally desirable alternatives, or with anticipation and highest and best use, which answer entirely different questions. Picture an appraiser in Princeton valuing a small, plain home tucked among large, expensive houses. Comparable small homes in uniform neighborhoods sold for less per square foot, so the appraiser recognizes the setting itself as lifting the subject's value. The worst house on the best street often outperforms the best house on a poor one. Progression lifts, regression drags. And once you hold both together, that odd per square foot swing stops looking like a glitch and starts looking like the market doing exactly what it should. Question 23. Under NJRE 11564, a New Jersey licensee owes an affirmative duty to deal honestly and to disclose certain conditions to consumers. Which of the following best identifies a condition the rule requires the licensee to disclose to the consumer absent a specific exemption? Your options are A. Known material defects affecting the property. B. The licensee's personal political affiliation. C. The seller's anticipated tax bracket. D. The buyer's expected renovation budget. Don't overthink it. Which one feels right? The correct answer is A. Known material defects affecting the property. This is correct because NJRE 11564 obligates licensees to disclose known material defects and material adverse facts to consumers. The duty runs to both clients and customers, and the failure to disclose can trigger commission discipline and civil liability. B is wrong because the licensee's personal political affiliation is not a property-related material fact and is not within the licensee's disclosure duty. Disclosure rules focus on conditions of the property and on facts affecting value or use. C is wrong because the seller's anticipated tax bracket is a private financial matter unrelated to the property's physical condition or value. It does not fall within the disclosure rules that require disclosing material defects. D is wrong because the buyer's expected renovation budget is the buyer's own confidential business decision. It is not a property-related material fact and does not fall within the licensee's disclosure obligations under the rule. New Jersey real estate licensees owe an affirmative duty of honesty. That means volunteering known material facts about a property without waiting for a buyer to ask. This duty exists to fix an imbalance of knowledge. A seller and their licensee may know about a flooding basement, a failing septic system, or a boundary dispute that a buyer simply cannot discover by looking. So New Jersey rejected pure buyer beware in favor of disclosure. The mechanism turns on two words, known and material. It covers defects the licensee actually knows about. and facts material enough to affect a reasonable buyer's decision or the property's value or use. The exam skill is separating material property facts from private information, a licensee's politics, a seller's tax bracket, and a buyer's renovation budget are none of the buyer's business and say nothing about the property, so only the flooding must be disclosed. A licensee who knows of a material defect and stays silent has breached the rule, inviting discipline and liability. Disclose the property's known significant problems and leave people's private lives out of it. Question 24. A property management agreement between a New Jersey broker and an owner typically addresses the broker's scope of authority, term and termination, compensation, owner obligations, accounting and reporting, and indemnity. Which of the following best identifies an additional core component such an agreement should include? Your options are A. Authority to file the owner's tax returns. B. Limitations of liability for the broker. C. Permission to forge the owner's signature. D. Power to convey owner property. Got a guess? Lock it in. The correct answer is B. Limitations of liability for the broker. B is correct because a property management agreement commonly includes limitations of liability that allocate risk between broker and owner. The agreement defines what the broker is and is not responsible for, and how disputes about losses or damages will be addressed. A is wrong because authority to file the owner's tax returns is a tax practice function. Real estate brokers do not file owner tax returns as part of property management. That is the role of an accountant retained by the owner. C is wrong because permission to forge the owner's signature is illegal in any context and could constitute criminal fraud. No legitimate property management agreement would purport to authorize forgery of an owner's signature. D is wrong because power to convey the owner's property at any price exceeds the scope of property management. Property managers manage operations. They do not have unfettered authority to sell the owner's real estate. A property management agreement doesn't just grant a broker power over an owner's property. It also has to define the limits of that power. Let's look at the component that does exactly that. A well-built agreement covers the scope of the broker's authority, the term, compensation, the owner's obligations, and accounting and reporting. The piece the exam highlights is the limitation of liability, the provision that allocates risk between broker and owner. Think of it like handing someone the keys to your building. You're granting real power to collect rents, sign vendors, and make daily calls, so you also need to agree in advance on who's responsible when a tenant is hurt or a vendor botches a repair. The limitation of liability provision settles that before any dispute happens, not after. It's important to distinguish this from provisions that don't belong at all. Authority to file tax returns belongs to an accountant. Permission to forge a signature is simply a crime. And unlimited power to sell the property goes beyond management entirely. Only the limitation of liability is a proper core component. A good management agreement grants power and bounds it in the same document. When a scenario asks what's missing from the standard list, the answer is the risk allocation provision, not tax filing, forgery, or unchecked selling power. Question 25. A licensee preparing a New Jersey residential contract for 1 to 4 family property crosses several lines by drafting an extensive custom indemnification provision and explaining its legal consequences to the buyer and seller. Which of the following best identifies the licensee's principal risk? Your options are A. Liability for procuring cause disputes. B. Violation of Real Estate Timeshare Act. C. Unauthorized practice of law. D. Loss of access to the MLS. Which one is it? Pause the video if you need more time. The correct answer is C. unauthorized practice of law. C is correct because drafting non-standard contract provisions and explaining their legal consequences is the unauthorized practice of law in New Jersey. The 1983 consent judgment permits licensees only to complete the standard form and explain its terms generally. A is wrong because procuring cause disputes arise over which broker earned the commission for a transaction. They concern broker-to-broker disagreements and are not the issue when a licensee crosses into legal practice by drafting bespoke contract clauses. B is wrong because the Real Estate Timeshare Act regulates the sale and registration of timeshare offerings. It has no application to a licensee who oversteps the contract drafting boundary on a single-family residential purchase contract. D is wrong because loss of MLS access is a private sanction by a multiple listing service and is not the principal risk of unauthorized legal practice. The greater risk is discipline by the Real Estate Commission and exposure to civil liability. Every real estate license has an invisible boundary, and past it lies the practice of law. The moment a licensee drafts custom legal provisions or advises on their legal consequences, that boundary is crossed. This crossing is called the unauthorized practice of law, and it's the biggest risk when a licensee gets ambitious with a contract. Legal drafting carries consequences that require legal training and legal accountability. A lawyer who writes a clause understands its reach and carries malpractice insurance, while a licensee who improvises the same language has none of that protection, even though the parties rely on it just the same. In New Jersey, a 1983 consent judgment drew this line precisely. Licensees may complete the standard form and explain its general provisions, but they may not draft non-standard clauses or advise on the legal consequences of contract terms. Completing a blank is permitted. Composing bespoke legal language is not. Picture a licensee in Atlantic City who writes an extensive custom indemnification clause and explains exactly how it shifts legal risk between buyer and seller. However well-intentioned, that is drafting and advising the work of a lawyer, not the safe standard form path. A licensee who stays within the standard form and refers legal questions to counsel is safe and useful. Staying on the licensee's side of that 1983 line is what protects both the license and the consumer. Question 26. A cost approach appraisal of an older Camden warehouse must distinguish between the cost of an exact duplicate using like-kind materials and the cost of a functional substitute built with current materials and methods. Which pair of terms best identifies these two cost measures? Your options are A. Capitalized value and effective value, B. External value and internal value, C. Insurable value and assessed value, D. Reproduction cost and replacement cost. Take a second. Which answer would you pick? The correct answer is D. Reproduction cost and replacement cost. D is correct because reproduction cost is the cost to build an exact duplicate using like-kind materials and methods. Replacement cost is the cost to build a functional substitute using current materials and methods. The cost approach often uses replacement cost for older buildings. A is wrong because capitalized value and effective value are not the standard cost approach terms for the two cost measures. Capitalization converts income to value in the income approach, and effective value is not a recognized appraisal term in this context. B is wrong because external value and internal value are not recognized appraisal categories. External obsolescence is a depreciation category, but it does not pair with internal value to describe the two cost measures used in the cost approach. C is wrong because insurable value is the cost to replace damage improvements for insurance coverage, and assessed value is the tax assessor's figure. Neither pairs with the other as the cost approach distinction the question describes. Two cost figures sound almost interchangeable but mean very different things in the cost approach to value. Reproduction cost is the price to build an exact duplicate, using the same materials and methods as the original, even outdated ones. Replacement cost is the price to build a functional equivalent that serves the same purpose using today's materials and standards. Picture an older warehouse with thick masonry walls, plaster finishes, and framing techniques no one uses anymore. Reproducing it exactly means sourcing obsolete materials at absurd cost, while replacing its function means pricing a modern warehouse of equal utility. The exam tests whether you can separate this pair from look-alike terms. Capitalized value comes from the income approach. Insurable value is for insurance coverage. And assessed value is a tax assessor's figure. None of them are the cost approach pair. Reproduction copies the past while replacement recreates the function. And for aging buildings, the functional equivalent is the more honest gauge of what the improvements are worth. Question 27. An appraiser values a Newark mixed-use building with retail on the ground floor and apartments above by capitalizing the net operating income into a present value, using a rate drawn from comparable investments. Which of the three approaches to value is being applied? Your options are A. Income approach, B. Cost approach, C. Sales comparison approach, D. Reconciliation method. Before I reveal it, which one do you think is righty? The correct answer is A. Income approach. A is correct because the income approach converts a property's future income stream into a present value, typically by dividing the net operating income by a market-derived capitalization rate. It is the primary approach for income-producing property like mixed-use buildings. B is wrong because the cost approach develops value as land value plus the depreciated cost of improvements. It is most useful for special-purpose property and new construction, not for an income-producing mixed-use building with active tenants. C is wrong because the sales comparison approach analyzes recent sales of similar properties. While useful, it is rarely the primary approach for income properties, where the income stream itself is the principal driver of value to a typical investor. D is wrong because reconciliation is the step where the appraiser weighs the three approaches and forms the final opinion. It is not itself one of the three approaches, although it appears in the report after the income approach has been completed. The income approach turns a property's earning power into a present value, based on the idea that an investor is really buying a future stream of rental income, not bricks and mortar. This rests on the principle of anticipation, the idea that present value reflects expected future benefits. That's why income properties like apartments, offices, retail, and mixed-use buildings rely on this approach above all others, since income is their entire purpose. The mechanism runs in 3 steps. First, estimate net operating income, rents and other income minus operating expenses and vacancy before debt service. Second, select a market-derived capitalization rate reflecting required investor return. Third, divide net operating income by that rate to get value. Picture a Newark mixed-use building with retail below and apartments above, rents minus expenses, and vacancy produce net operating income. And dividing that by a market capitalization rate yields the value an investor should rationally pay. Net operating income divided by a market capitalization rate turns future rent into present price, and the approach's accuracy lives or dies on how well that rate reflects the market. Question 28. A New Jersey licensee in Cherry Hill sends commercial email advertisements to a large list of consumers and receives complaints about deceptive subject lines and missing unsubscribe options. Which federal statute best regulates commercial email content and unsubscribe mechanics for these messages? Your options are RESPA Section 8, B. the Con-Spam Act, C. the Sherman Antitrust Act, D. the Telephone Consumer Protection Act. What's your answer? Commit to one before I continue. The correct answer is B, the CAN-SPAM Act. B is correct because the CAN-SPAM Act regulates commercial email content, requiring accurate header information, non-deceptive subject lines, identification as an advertisement when applicable, a valid physical address, and a clear and functional unsubscribe mechanism. A is wrong because RESPA Section 8 prohibits kickbacks and unearned fees in settlement services. It is a real estate settlement statute, not a commercial email regulation governing subject lines and unsubscribe mechanics. C is wrong because the Sherman Antitrust Act prohibits anti-competitive agreements among competitors at the federal level. It is a competition law statute and does not regulate commercial email content or unsubscribe mechanics for marketing emails. D is wrong because the Telephone Consumer Protection Act regulates telemarketing calls and certain text messages to consumers. It addresses telephone-based communications, not the commercial email content that the CAN-SPAM Act governs directly. Commercial email is cheap to send at massive scale, and that cheapness invites abuse, disguised ads, forged senders, and unsubscribed links that go nowhere. The federal CAN-SPAM Act exists to stop exactly that, setting baseline honesty and control rules for commercial email. The mechanism is concrete. Header and sender information must be accurate. Subject lines must not deceive. Advertisements must be clearly labeled. A valid physical postal address is required. And above all, every message needs a functional opt-out that senders honor promptly. The exam tests whether you can separate CAN-SPAM from lookalikes. A settlement services kickback rule covers real estate closing fees. An antitrust statute bans anti-competitive agreements. And a telephone consumer protection law governs calls and texts. Only CAN-SPAM reaches commercial email subject lines and unsubscribe mechanics. Picture the compliant email itself: an honest sender name, a truthful subject line, a clear ad label, a real physical address, and a working unsubscribe link, all in one message. A Cherry Hill licensee sending listing blasts with bait and switch subject lines and dead unsubscribe links is committing CAN-SPAM violations, not some other offense. Commercial email is regulated speech. Be honest about who you are and what the message is, and always give recipients a real way out. Question 29. An instructor reviews the fiduciary duties an agent owes a client under common law, captured in the mnemonic old car. Which of the following options correctly identifies what the letters in old car represent in the duties owed by an agent to a principal? Your options are A. Obedience, loyalty, care, confidentiality, disclosure, reasonable accounting. B. Order, loyalty, disclosure, compliance, authority, record keeping. C. Obedience, loyalty, disclosure, confidentiality, accounting, reasonable care. D. Ownership, loyalty, disclosure, capital, accounting, records. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. Obedience, loyalty, disclosure, confidentiality, accounting, reasonable care. C is correct because OLD-CAR stands for obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. These are the core common law fiduciary duties an agent owes the principal, and New Jersey expects them to govern the licensee-client relationship. A is wrong because this option reorders the letters and rephrases the duties incorrectly. The standard mnemonic places obedience and loyalty first, then disclosure and confidentiality, and the recognized last letters stand for accounting and reasonable care. B is wrong because order, compliance, authority, and record keeping are not the recognized fiduciary duties under old CAR. The mnemonic uses specific terms drawn from common law that this answer does not match. D is wrong because ownership and capital are not fiduciary duties an agent owes the principal. The accurate list focuses on the agent's conduct and the special trust the principal places in the agent, not on ownership or capital concepts. When a client hires an agent, the law imposes fiduciary duties, the highest standard of care one person can owe another in a business relationship. In real estate, common law captures those duties with the mnemonic old car. The principal grants the agent authority and relies on the agent's expertise, often for the biggest financial decision of their life. That trust would be hollow without enforceable duties. So the fiduciary framework binds the agent to loyalty and care. Ordinary deals don't demand. Obedience means following lawful instructions. Loyalty means putting the principal's interests first. Disclosure means sharing material facts. Confidentiality means guarding private information even after the relationship ends. Accounting means tracking money and property. And reasonable care means bringing real competence to the work. Picture an agent handling listing where the seller will accept less than asking price. Loyalty and confidentiality forbid leaking that number to a buyer. Disclosure requires passing material facts to the seller. Accounting requires tracking any deposit. And reasonable care requires doing the whole job competently. Exam traps swap in near misses like order, compliance, or ownership. But the real six are obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. That precise standard is what separates representing a client from merely helping a customer. Question 30. An owner in Hunterdon County sells a residential property served by a private well. New Jersey law requires the seller to have the well water tested for specific contaminants and to give the results to the buyer before closing. Which statute best imposes this testing obligation? Your options are A. The Coastal Area Facility Review Act, B. The Highlands Water Protection Act, C. The Pinelands Protection Act, D. The Private Well Testing Act, PWTA. Which would you go with? Lock it in before the reveal. The correct answer is D. The Private Well Testing Act, PWTA. D is correct because the Private Well Testing Act requires sellers of residential properties served by a private well to have the well water tested for specified contaminants by a certified laboratory and to provide the results to the buyer before closing the transaction. A is wrong because the Coastal Area Facility Review Act regulates major development in the Atlantic coastal zone. It does not impose private well water testing requirements on residential property transactions involving wells across New Jersey. B is wrong because the Highlands Water Protection Act protects the Highlands region in northwestern New Jersey through development limits. It is a regional preservation statute, not the well water testing requirement at residential closings. C is wrong because the Pinelands Protection Act regulates development inside the Pinelands area through the Pinelands Commission. It is a land use statute, not the residential private well testing requirement the question describes. Public water systems have a utility watching over them, but a private well has no such guardian. New Jersey's Private Well Testing Act makes sure a home buyer learns exactly what is in that well's water before closing, not after moving in. The problem is invisible contamination, arsenic radionuclides, or runoff from nearby land use, none of which announces itself by taste or smell. Without testing, that risk transfers silently to a family who may drink it for years before a problem ever surfaces. The mechanism is simple. When a home with a private well is sold, a certified laboratory must test the water and the results must reach the buyer before closing. That lets the buyer negotiate treatment or remediation with real data in hand, rather than guessing. Don't confuse this with New Jersey's regional land use laws. Coastal Facility Review governs shore development. Highlands Protection limits building in the northwest to guard water supply, and Pinelands Protection oversees a dedicated preservation area, but none of them require testing well water at a residential closing. Only the Private Well Testing Act does that. A private well transfers with the home, and New Jersey insists the water be tested and disclosed before that sale is final. Whenever a STEM describes a residential well sale with a duty to test and share results, this is the statute at work. Question 31. A New Jersey real estate licensee suspects a buyer is using a non-financed all-cash purchase of a residential property through a trust to obscure beneficial ownership. The licensee should be aware that anti-money laundering reporting may apply at closing. Which federal authority best oversees this AML framework? Your options are A. FinCEN, Financial Crimes Enforcement Network; B. The Federal Aviation Administration; C. The U.S. Securities and Exchange Commission; D. The National Park Service. Don't overthink it. Which one feels right? The correct answer is A. FinCEN, Financial Crimes Enforcement Network. A is correct because FinCEN within the U.S. Treasury administers the Bank Secrecy Act and the Residential Real Estate Reporting Framework. The 2025 Residential Real Estate Rule requires reporting of certain non-finance transfers to legal entities and trusts to deter money laundering. B is wrong because the Federal Aviation Administration regulates civil aviation in the United States, including airspace and airport operations. It has no role in anti-money laundering oversight of residential real estate transactions. That is FinCEN's responsibility. C is wrong because the U.S. Securities and Exchange Commission regulates the issuance and trading of securities. It has no role in the residential real estate anti-money laundering framework, which is administered by FinCEN. D is wrong because the National Park Service manages the national parks and federal monuments across the United States. It has no role in anti-money laundering oversight of residential real estate transactions or any related FinCEN reporting requirements. An all-cash offer on a house with title taken by a trust or shell company whose real owners are hard to trace should raise a quiet flag for any licensee. That pattern is a classic way to launder illicit money into real estate, and one federal authority is built to catch it: FinCEN, the Financial Crimes Enforcement Network. FinCEN sits inside the Treasury and administers the Bank Secrecy Act, the nation's core anti-money laundering law. Real estate attracts launderers because a property can absorb huge sums at once, and paying all cash skips the bank that would normally scrutinize the funds. FinCEN exists to close that blind spot. The Residential Real Estate Rule, finalized in 2025, requires reporting of non-finance transfers of residential property to legal entities and trusts. With no lender to run checks, the duty shifts to settlement professionals. So an anonymous cash purchase doesn't just vanish from view. The exam often tests this by mixing in unrelated agencies. An aviation regulator oversees airspace and airports, a securities regulator polices stocks and bonds, and a national parks agency manages public lands. None of them touch money laundering through real estate. That mission belongs to FinCEN alone. Real estate can be a laundry for illicit money, and FinCEN is the authority charged with stopping it whenever cash, speed, and an anonymous entity appear together in a scenario. FinCEN and the Bank Secrecy Act are the framework in view. Question 32. A New Jersey buyer sues a seller and the seller's licensee for failure to disclose a known leaking underground oil tank, citing the Consumer Fraud Act. If the buyer prevails on liability and proves an ascertainable loss, what is the principal CFA damage remedy? Your options are A. Double the amount of actual damages; B. Treble damages plus reasonable attorney fees; C. Punitive damages capped at $10,000; D. Specific performance to repair the tank. Got a guess? Lock it in. The correct answer is B. Treble damages plus reasonable attorney fees. B is correct because the New Jersey Consumer Fraud Act provides treble damages and reasonable attorney fees on proof of an unlawful practice and an ascertainable loss. This remedy has made the CFA a powerful tool in residential real estate disclosure disputes. A is wrong because double damages is the Security Deposit Statute's penalty for wrongful retention of a deposit. It is not the Consumer Fraud Act remedy. The CFA provides triple damages, not double damages, for unlawful practices. C is wrong because punitive damages capped at $10,000 is not a recognized CFA remedy. The CFA's signature remedy is automatic trebling of compensatory damages plus reasonable attorney fees, not a capped punitive award. D is wrong because specific performance to repair the tank is not the CFA remedy. The CFA provides money damages and attorney fees. Equitable remedies like specific performance are governed by separate common law principles. The signature remedy of the New Jersey Consumer Fraud Act is treble damages plus reasonable attorney fees. A plaintiff who proves a violation and an ascertainable loss recovers 3 times the actual damages, and the wrongdoer pays the plaintiff's legal fees on top. The remedy exists to change the economics of consumer wrongdoing. If a seller only had to repay actual harm, cheating and settling would cost nothing. But tripling damages and shifting attorney fees means the wrongdoer faces far more than the harm caused, while the victim can now afford a lawyer. The mechanism has defined elements. The plaintiff must show an unlawful practice, an affirmative misrepresentation, a knowing omission of a material fact, or a violation of a regulation under the Act, and must show an ascertainable loss caused by that practice. Once established, trebling and fee shifting follow automatically. The exam rewards separating this remedy from similar sounding ones. Double damages is the Security Deposit Statute's penalty for wrongful retention, twice, not 3 times, and an entirely different law. A capped punitive award isn't how the Act works, since trebling is automatic on proof, and specific performance is an equitable contract remedy ordering performance, not the Act's money remedy. Consider a buyer who discovers after closing that the seller and the seller's licensee knew about a leaking underground oil tank and said nothing. If the buyer proves the concealment was an unlawful practice and shows an ascertainable loss, the recovery is triple the actual damages plus reasonable attorney fees. Whenever a STEM describes a New Jersey consumer proving an unlawful practice and an ascertainable loss, the remedy in view is treble damages plus reasonable attorney fees, designed to deter deceptive practice, not just compensate for it. Question 33. The New Jersey Fair Chance and Housing Act restricts when and how a landlord may consider a rental applicant's criminal history. The statute generally prohibits the landlord from asking about criminal history before a specific stage in the application process. Which of the following best identifies that timing rule? Your options are A. Before any showing of the unit, B. Before the lease is fully executed, C. Before the landlord makes a conditional offer, D. Before tenant pays first month's rent. Which one is it? Pause the video if you need more time. The correct answer is C. Before the landlord makes a conditional offer. C is correct because the NJ Fair Chance and Housing Act generally prohibits inquiries into an applicant's criminal history until after the landlord has made a conditional offer of tenancy. Even then, the law limits the kinds of records that may justify denial. A is wrong because before any showing of the unit is too early under the statute. The Act allows the landlord to evaluate other qualifications first and forbids criminal history inquiries before a conditional offer of tenancy has been extended. B is wrong because before the lease is fully executed is too late under the statute. The conditional offer stage triggers when criminal history inquiries are permitted. The lease execution stage comes later, after acceptance. D is wrong because before the tenant pays, the first month's rent is unrelated to the timing rule. The statute keys the inquiry permission to the conditional offer of tenancy, not to the payment of any rent. The New Jersey Fair Chance and Housing Act isn't about banning criminal history checks. It's about controlling exactly when that check can happen. When criminal history comes first, it can taint the whole evaluation, sinking a qualified applicant before income or references even get weighed. So the law flips the order, forcing ordinary qualifications to be judged first. The landlord first evaluates income, references, and ability to pay. Only after making a conditional offer of tenancy can the landlord ask about criminal history, and even then, must do an individualized assessment before pulling the offer. The exam test whether you can spot the exact trigger. Barring inquiry before any showing is too early, waiting until the lease is executed is too late, and tying it to first month's rent misses the mark entirely. The conditional offer of tenancy is the one true gate. This sequencing strategy shows up across fair chance laws because once someone is already judged qualified, a landlord is less likely to reject them reflexively. Fixing that one moment, the conditional offer of tenancy, is the key to the whole rule. Question 34. A New Jersey tenant exercising rights under the Marini Repair and Deduct Doctrine must follow certain steps to protect the right to deduct the cost of repair from rent. Which of the following best identifies one of the steps a tenant generally must take before invoking the remedy? Your options are A. File a federal civil rights action. B. Move out without notice to the landlord. C. Surrender the lease immediately. D. Give landlord notice and chance to repair. Take a second. Which answer would you pick? The correct answer is D. Give landlord notice and chance to repair. D is correct because a tenant invoking the Marini Doctrine must give the landlord notice of the defect and a reasonable opportunity to repair. Only after the landlord fails to act may the tenant make essential repairs and deduct the reasonable cost from rent. Is wrong because filing a federal civil rights action is not a prerequisite to the Marini remedy. Civil rights claims involve protected classes. The Marini Doctrine is a private landlord-tenant remedy that operates on state law principles. B is wrong because moving out without notice to the landlord is constructive eviction territory, a different doctrine. Marini lets the tenant stay and repair after notice and opportunity to repair, not vacate without notice. C is wrong because surrendering the lease immediately ends the tenancy and forfeits the right to repair and deduct. Marini contemplates continued occupancy with self-help repair after the landlord fails to act within a reasonable time. The Marini repair and deduct remedy lets a residential tenant fix a serious defect the landlord has ignored and subtract the reasonable cost from rent, but only after following required steps. Because it is self-help, the law hedges it with conditions. The doctrine comes from Marini versus Ireland, which recognized an implied warranty of habitability requiring landlords to keep a unit fit to live in. Before this ruling, a tenant facing broken heat or plumbing had little recourse besides moving out or filing suit. The mechanism is a strict sequence. First, the defect must affect habitability, not just be cosmetic. Second, the tenant must notify the landlord and allow reasonable time to repair. Third, only if the landlord fails to act may the tenant arrange the repair and deduct the cost. Picture a tenant in Newark whose heating system fails in winter. The tenant notifies the landlord and waits a reasonable time. When the landlord does nothing, the tenant hires a technician, pays to restore the heat, and deducts that cost from next month's rent, keeping documentation throughout. Don't confuse this with similar responses. A civil rights action addresses discrimination, not habitability. Moving out without notice suggests constructive eviction, and surrendering the lease ends the tenancy entirely. Marini requires the tenant to stay, give notice, and repair only after the landlord defaults, since notice is the fairness core protecting the remedy from abuse. Question 35. An appraiser estimates value for an unusual public library in Trenton by adding the depreciated cost of the building improvements to the underlying land value. Which of the three approaches to value is the appraiser primarily using for this property? Your options are A. Cost approach, B. Income approach, C. Sales comparison approach, D. Reconciliation method. Before I reveal it, which one do you think is right? The correct answer is A. Cost approach. A is correct because the cost approach develops value as land value, plus the current cost to reproduce or replace the improvements. Less accrued depreciation. It is well suited to special purpose property like libraries and schools, where sales and income data are scarce. B is wrong because the income approach capitalizes the future income of a property into a present value. A public library does not produce rental income from tenants, so the income approach is not the primary method for estimating its value. C is wrong because the sales comparison approach relies on recent sales of comparable properties. Public libraries rarely sell in the open market, so the sales comparison approach has little data to work with for a property of this type. D is wrong because reconciliation weighs the indications from the three approaches. It is not an approach itself. The question asks which approach is being used for the primary calculation, and that calculation rests on land value plus depreciated cost. Some properties like libraries, schools and churches almost never sell and never earn rent. That makes two of the three valuation approaches useless and leaves one method to carry the whole appraisal. The income approach converts rent into value, but a public library earns no rent. The sales comparison approach relies on comparable sales, but libraries rarely sell. The cost approach needs neither, so it becomes the natural fit. The mechanism has 3 steps. First, estimate the land value, often by comparing to land sales. Second, estimate the current cost to reproduce or replace the improvements. Third, subtract accrued depreciation from physical wear, functional obsolescence, and external factors. Picture an appraiser valuing an unusual public library. There are no comparable sales and no rent to capitalize, so the appraiser estimates land value, calculates the cost to build an equivalent structure, subtracts depreciation, and adds the two figures together. The cost approach is indispensable exactly where sales and income data are thin, though it depends heavily on judging depreciation accurately. When a scenario values a special purpose building by adding land value to depreciated improvement cost, the cost approach is the method at work. Question 36. An instructor in Newark reviews the foundational elements that must come together for a real estate contract to be legally valid and enforceable. The list includes a lawful object, mutual assent, consideration, and parties with legal capacity. Which of the following is also a required element of a valid contract? Your options are A. A title insurance policy, B. Offer and acceptance, C. A recorded mortgage, D. A real estate commission. What's your answer? Commit to one before I continue. The correct answer is B. Offer and acceptance. B is correct because a valid contract requires offer and acceptance, mutual assent, consideration, legal capacity, lawful purpose, and a writing where the statute of frauds demands it. Offer and acceptance is the moment of agreement that ties the parties together legally. A is wrong because a title insurance policy protects an owner or lender against title defects after closing. It is a closing-related product and not one of the elements that must be present for a real estate contract to be valid. C is wrong because a recorded mortgage is a separate security document arising in the financing process. Recording governs lien priority and constructive notice, but it does not figure in the list of essential elements for forming a valid contract. D is wrong because a real estate commission is the broker's earned compensation under a listing agreement. It addresses a fee owed to a licensee and is not a requirement that must be present for a valid contract between buyer and seller to exist. A valid contract isn't one thing. It's a set of elements that all must be present, or there's no enforceable agreement at all. Real estate courses list mutual assent, consideration, legal capacity, lawful object, and sometimes a writing. Each guards against a different failure. Capacity ensures competence. Lawful object bars illegal deals, and consideration ensures a real bargain. Offer and acceptance sits at the heart of that list, because it's the mechanism through which mutual assent actually forms. One party offers, the other accepts the exact terms. If the terms change, it's a counteroffer, a new offer entirely. Picture a buyer submitting a written offer on a home with a price and terms, and the seller signing to accept those exact terms. At that instant, assuming capacity, consideration, and lawful objects are already met, mutual assent exists and the contract is formed. A deal can have capable parties, a lawful object, and consideration on the table and still be no contract without an accepted offer. Offer and acceptance is the missing essential that actually creates the agreement. Question 37. A residential tenant in Newark withholds rent because of serious habitability defects the landlord has failed to repair, then defends the resulting eviction case on the habitability defects as a defense. Which New Jersey Supreme Court decision best authorizes the rent withholding and habitability defense? Your options are Marini v. Ireland, B. Strawn v. Canuso, C. Bezito v. Gambino, D. Weintraub v. Krolbach. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. Bezito v. Gambino. C is correct because Bezito v. Gambino, 63 NJ, 460, 1973, extended Marini and allowed tenants to withhold rent based on habitability defects. The court permitted tenants to assert breach of the implied warranty of habitability as a defense in summary dispossess actions. A is wrong because Marini v. Ireland established the implied warranty of habitability and the repair and deduct remedy. The rent withholding doctrine with a habitability defense extends from Bezito, which built on Marini's foundational warranty. B is wrong because Strawn v. Canuso addressed the developer's duty to disclose off-site conditions in new construction. It is a sales disclosure case, not the rent withholding and habitability defense case for residential tenants. D is wrong because Weintraub v. Krolbach addressed the seller's duty to disclose known latent defects on the property. It is a sales disclosure case, not the rent withholding and habitability defense case in landlord-tenant law. New Jersey tenant law was built case by case, and Bezito v. Gambino, decided in 1973, is the decision that let tenants withhold rent when a landlord fails to keep a unit habitable. Bezito established that every lease carries an implied warranty of habitability. If the landlord breaches it through serious defects, the tenant's rent obligation shrinks, and the tenant can assert that breach affirmatively in court. The mechanism works like this. A tenant facing an unfixed habitability defect withholds rent. The landlord sues to evict for non-payment, and the tenant raises the defect as a defense. The court then measures how much the defect lowered the unit's value and adjusts the rent owed. Don't confuse the neighbors. Marini recognized the warranty and the repair and deduct remedy. Bezito extended it into a withholding and defense posture. Strawn and Weintraub are sales disclosure cases about buyers, not tenants at all. whenever a tenant withholds rent over uninhabitable conditions and defends the eviction on those grounds. Bozito versus Gambino is the decision behind it, extending the warranty Marini first recognized. Question 38. A New Jersey listing terminates by performance when the property is sold and closing occurs without dispute. Outside of that natural completion path, which of the following best identifies another common way the agency relationship between a seller-client and a brokerage firm comes to an end? Your options are A. Acceptance of the buyer's deposit by escrow. B. Death of the licensee's sponsoring broker. C. Renewal of the broker's continuing education credits. D. Expiration of the listing's stated term. Which would you go with? Lock it in before the reveal. The correct answer is D. Expiration of the listing's stated term. D is correct because expiration of the stated term ends the agency by operation of the contract. A listing typically runs for a defined period, and absent renewal, the agency relationship ends when the term expires, unless the parties agree to extend. A is wrong because acceptance of the buyer's deposit by escrow is a step in the transaction, not a termination event for the agency. The agency continues through the closing process if the listing runs through and the parties perform. B is wrong because death of the licensee's sponsoring broker affects the licensee's affiliation rather than the listing between seller and firm. The firm continues as the brokerage, and the agency does not end simply because one principal licensee dies. C is wrong because renewal of the broker's continuing education credits is a licensure compliance matter. It does not terminate or affect an existing brokerage agreement between the firm and a seller client. A listing agreement isn't forever. It's a contract with a defined life, and the exam wants you to recognize all the ways that contract can come to an end. An agency can end by performance when the sale closes, by expiration when the stated term lapses, by mutual agreement when both parties consent to cancel, by revocation or renunciation, or by operation of law, such as destruction of the property or death of a principal. Expiration is the most common ending after a listing simply runs its course unsold. It's just as important to know what does not end a listing. Accepting a buyer's deposit into escrow is just a step toward closing. The death of an individual salesperson doesn't end the firm's listing. And renewing continuing education credits is pure licensing housekeeping. The subtle point students miss is that the listing agreement is between the seller and the brokerage firm, not an individual salesperson. That's why one agent leaving or dying doesn't end the listing. The firm remains the true principal party. A listing ends by performance when the sale closes, but the ordinary way it ends short of a sale is expiration of its stated term, running out like the calendar it was built on. Question 39. An owner in Camden faces multiple recorded encumbrances on the same parcel, including a property tax delinquency, a first mortgage, and a recorded judgment from a personal injury lawsuit. When the property is sold at a sheriff's sale, which lien generally takes the highest priority? Your options are A. The municipal property tax lien, B. The first mortgage, C. The recorded personal injury judgment, D. Whichever lien was recorded first. Don't overthink it, which one feels right? The correct answer is A. The municipal property tax lien. A is correct because property tax liens are super priority liens that come ahead of mortgages and most other claims, regardless of recording order. New Jersey municipalities depend on tax collections, so the statute moves these liens ahead of private creditors at distribution. B is wrong because a first mortgage holds high priority among private lenders and against later recorded interest. It nevertheless sits behind a municipal property tax lien, which by statute jumps ahead of even a properly recorded first mortgage at sale. C is wrong because a personal injury judgment becomes a general lien on the debtor's property once it is docketed. Even when recorded, it lines up behind property tax liens and behind any mortgage that was recorded before the judgment was entered. D is wrong because first to record priority is the usual rule among private liens of equal type, but it does not override the statutory super priority of property tax liens. A late tax lien still leaps to the front when the property is sold. Lien priority usually follows first in time, first in right. Whichever lien recorded earliest gets paid first. But property tax liens are the great exception, jumping ahead of everything else, no matter when they arose. The exception exists because local government depends on property tax revenue to function. If a bank's mortgage could outrank the town's tax lien, foreclosure could starve schools, police, and roads of funding. So the law grants tax liens the top spot automatically. At a forced sale, proceeds are distributed by this order. The municipal tax lien is paid first, the first mortgage second, and a recorded judgment last only if money remains. The tax lien's top spot doesn't depend on being recorded first. The statute simply grants it. This is exactly why lenders escrow for property taxes. A lender knows unpaid taxes can leap ahead of its own lien, so it collects tax payments monthly and pays the taxing authority directly. An everyday practice built entirely around super priority. So when a parcel with a tax delinquency, a mortgage, and a judgment sells at share of sale, taxes are paid first, then the mortgage, then the judgment. Property tax lines hold super priority over the ordinary first-in-time rule, and that's the fact the exam is testing. Question 40. A buyer in Trenton in 2026 closes on a residential property and receives a deed signed by a non-resident seller. The buyer or settlement agent must address NJ gross income tax compliance for the non-resident seller using the appropriate state form. Which form best identifies the correct compliance vehicle? Your options are A. Form W-9 only, B. GIT and REP series of forms, C. FinCEN Boy report only, D. FEMA flood disclosure only. Got a guess? Lock it in. The correct answer is B. GIT and REP series of forms. B is correct because the GIT and REP series, including GIT REP 1 for non-resident estimated tax payment, GIT REP 3 for resident exemption and other variants, addresses gross income tax compliance at the closing of New Jersey real property sales involving non-resident sellers. A is wrong because Form W-9 is a federal IRS form for requesting a taxpayer identification number. It is not the state form for non-resident sellers' NJ gross income tax compliance at a New Jersey real estate closing. C is wrong because the FinCEN Beneficial Ownership Information Report addresses federal anti-money laundering disclosure. It is unrelated to the state gross income tax compliance required of non-resident sellers at a New Jersey closing. D is wrong because the FEMA flood disclosure addresses the new 2024 New Jersey flood risk notification law. It is a disclosure form to the buyer or tenant, not the state tax compliance form for a non-resident seller's GIT obligations. When a non-resident sells New Jersey property, the buyer's side inherits a compliance chore. The county clerk won't record the deed unless the seller's gross income tax obligation is addressed with the correct GIT, CHA, or REP form. New Jersey won't record a deed from a non-resident seller without the matching GIT REP form. Recording is what gives the buyer a publicly noticed protected ownership interest, so the settlement agent has to see this form through. The settlement agent identifies the seller's status, picks the matching form from the GIT REP series, collects any estimated payment due, and submits it with the deed so recording can proceed. Don't confuse this with other closing paperwork. A federal taxpayer ID request, a beneficial ownership report, and a flood risk notification each serve a different purpose entirely. Only the GIT and REP series covers the seller's New Jersey tax compliance. Whenever a buyer or settlement agent closes with a non-resident seller in New Jersey, the GIT and REP series is the compliance vehicle that lets the deed record and the buyer take clean title. Question 41. A New Jersey landlord of a building covered by the Rent Security Deposit Act must hold each tenant's deposit in a specific kind of account and may collect a maximum amount tied to monthly rent. Which of the following best identifies the maximum permitted security deposit under NJSA 46.821.2? Your options are A. 3 months rent, B. 5 months rent, C. 1 1/2 months rent, D. 6 months rent. Which one is it? Pause the video if you need more time. The correct answer is C. 1 1/2 months rent. C is correct because under NJSA 46.821.2, a residential landlord may not collect a security deposit exceeding 1 1/2 times the monthly rent. The landlord must hold the deposit in a separate interest-bearing or money market account and pay accrued earnings to the tenant. A is wrong because 3 months rent exceeds the statutory cap. Collecting that amount as a security deposit on a covered residential rental violates NJSA 46.821.2 and exposes the landlord to refund and damages claims. B is wrong because 5 months rent grossly exceeds the statutory cap. New Jersey allows no more than 1 1/2 months rent as a residential security deposit, and a 5-month figure is far outside that limit. D is wrong because 6 months rent grossly exceeds the statutory cap. The Rent Security Deposit Act allows no more than 1 1/2 months rent, and a 6-month figure would be unenforceable and subject to refund. New Jersey law fixes a hard ceiling on residential security deposits, 1 1/2 times the monthly rent. This isn't a guideline a landlord can stretch when a tenant seems risky. It's a statutory maximum, and collecting more is illegal no matter how it's labeled. The cap exists to balance two real needs. A landlord wants protection against unpaid rent and damage, while a tenant needs to move in without handing over a crippling sum. New Jersey decided 1 1/2 months strikes that balance, protecting the landlord without locking up too much of the tenant's income. The mechanism includes more than the ceiling. The deposit must sit in a separate account, never mixed with the landlord's own funds, and the tenant is entitled to the interest it earns, with the landlord required to disclose exactly where it's held. Throughout the tenancy, that money never stops being the tenant's. The landlord merely holds it in trust against specific losses, and must return it with earned interest, itemizing any deductions within the statutory time after the tenancy ends. So when a scenario asks the maximum a covered landlord may collect, the answer is 1 1/2 months rent. Anything higher, whether 3, 5, or 6 months, crosses the line and exposes the landlord to refund claims and penalties. Question 42. A borrower in Princeton pays 1 point at closing on a $100,000 mortgage to reduce the interest rate over the life of the loan. Which of the following best identifies this prepaid interest paid to lower the rate? Your options are A. Origination point, B. Annual percentage rate, C. Earnest money deposit, D. Discount point. Take a second. Which answer would you pick? The correct answer is D. Discount point. D is correct because a discount point is prepaid interest equal to 1% of the loan amount, paid to buy down the interest rate over the life of the loan. Origination points compensate the lender for processing and do not reduce the rate. A is wrong because an origination point compensates the lender for processing and underwriting and does not lower the interest rate. The question describes a payment whose purpose is to reduce the rate, which is the function of a discount point. B is wrong because the annual percentage rate is a disclosed cost figure that includes interest and certain fees over the life of the loan. It is a disclosure metric, not a payment a borrower makes at closing to buy down the note rate. C is wrong because an earnest money deposit is a buyer's good faith payment with the contract held in escrow. It does not change the interest rate on the loan and is not a payment made to the lender at closing. A discount point is prepaid interest a borrower pays at closing to lower the interest rate for the entire life of the loan. 1 point equals 1% of the loan amount, and paying it trades a lump sum today for a lower monthly payment and less total interest over the years ahead. This exists because borrowers and lenders value money over time differently. A borrower planning to keep the loan for many years may prefer paying upfront to lock in a permanently lower rate, since the monthly savings eventually outweigh that initial cost. The mechanism is simple. 1 point costs 1% of the loan, paid at closing, and the lender reduces the rate in return. Pay more points, bar the rate down further, but the upfront cost only pays off if the borrower holds the loan long enough for monthly savings to exceed what the points cost. The exam checks whether you can separate a discount point from similar looking charges. An origination fee also costs 1% but pays the lender for processing, not for lowering the rate. The APR is a disclosed cost measure, not a payment, and earnest money is simply a buyer's deposit held in escrow unrelated to the rate. Both fees cost 1% and are paid at closing, yet they do opposite jobs. Remember, a discount point is prepaid interest that buys down the rate for the life of the loan, distinct from any fee that merely compensates the lender. Question 43. A grantor in Trenton conveys the same parcel to two different grantees on the same day. New Jersey's recording statute determines which grantee prevails based on a combination of recording and notice. Which type of recording statute best describes New Jersey's approach? Your options are E. Race notice statute, B. Pure race statute, C. Pure notice statute, D. First acceptance statute. Before I reveal it, which one do you think is right? The correct answer is A. Race notice statute. A is correct because New Jersey applies a race notice recording statute. A later good faith purchaser who records first prevails over an earlier grantee who failed to record, provided the later purchaser had no actual or constructive notice of the prior unrecorded interest. B is wrong because a pure race statute protects whichever grantee records first, regardless of notice. New Jersey adds a notice requirement. The later purchaser must also lack notice of the prior interest to prevail, which is the race notice combination. C is wrong because a pure notice statute protects whichever subsequent purchaser takes without notice, regardless of whether the purchaser recorded first. New Jersey requires both lack of notice and the first recording, so it is not a pure notice jurisdiction. D is wrong because a first acceptance statute is not a recognized recording statute category. Recording statutes use the race notice or race notice categories. First acceptance is not one of them in any U.S. jurisdiction. When a dishonest grantor sells the same land to two different buyers, someone has to win. Recording statutes exist to decide that fight cleanly, and New Jersey uses one specific rule to do it: race notice. A deed is valid the moment it's delivered, but the rest of the world can't see it. Recording statutes create a public filing system so ownership becomes knowable, protecting good faith purchasers who play by the rules. There are three real types. A pure race statute rewards whoever records first, period, even a buyer who knew about the earlier deed. A pure notice statute protects any good faith buyer regardless of recording order. New Jersey demands both no notice and record first. First acceptance isn't a recognized category at all. Picture a grantor in Trenton conveying the same lot to two grantees on the same day. The one who took without notice of the other's claim and reached the recording office first is the legal owner, even if the other buyer was equally innocent but slower. Race notice rewards the diligent buyer twice over. Check the record for prior claims, then record immediately. Miss either step and you lose the statute's protection. Question 44. A residential landlord in Trenton must register the property under the hotel and multiple dwelling law if the building meets certain size thresholds. The registration is filed with the Department of Community Affairs and creates ongoing inspection obligations. Which size best triggers the multiple dwelling registration requirement? Your options are A. Single family detached homes only. B. 3 or more residential units. C. 5 or more residential units. D. 20 or more residential units. What's your answer? Commit to one before I continue. The correct answer is B. 3 or more residential units. B is correct because the hotel and multiple dwelling law generally treats a building with 3 or more residential units as a multiple dwelling subject to registration with the Department of Community Affairs and to ongoing 5-year inspection cycles. A is wrong because single-family detached homes are not multiple dwellings and do not trigger the statute. The statute starts to apply when the building reaches the 3-unit threshold and is not aimed at one-family ownership. C is wrong because 5 or more residential units exceeds the actual statutory threshold for the multiple dwelling definition. The hotel and multiple dwelling law begins to apply at 3 units, not at 5. D is wrong because 20 or more residential units far exceeds the actual statutory threshold for the multiple dwelling definition. The hotel and multiple dwelling law begins to apply at 3 units, not at 20. New Jersey's hotel and multiple dwelling law switches on at exactly 3 residential units. Below that number, a building is outside the statute entirely. At 3, an entire regulatory regime begins. Think about why 3 is the line. A 2-family house is still a small owner-scale arrangement, but a 3-unit building starts to look like a business housing multiple unrelated households, so the state steps in. The law protects tenants who share stairwells, heating plants, and roofs but have little individual power to force repairs. More units means more tenants, and more tenants means more reason for the state to inspect. The mechanism is simple. Registration with the Department of Community Affairs, followed by a recurring inspection cycle, generally every 5 years. Registration puts the building on the state's radar, and inspection keeps it there, creating an ongoing duty rather than a one-time filing. Whenever a question asks what size triggers multiple dwelling registration, the answer is 3 units, not 5, not 20. That 3rd unit is what brings the hotel and multiple dwelling law into force. Question 45. A property manager in Newark sets rent for vacant units by analyzing recent rental comparables, the building's operating expenses, vacancy allowances, and local rent control overlays where applicable. Which of the following best identifies the rental analog of a sales comparative market analysis the manager is performing? Your options are A. USPAP compliant appraisal report. B. Federal Law HTC compliance audit. C. A rental market analysis, rental CMA. D. A 1031 like-kind exchange filing. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. A rental market analysis, rental CMA. C is correct because a rental market analysis or rental CMA uses direct comparable rents and operating data to set rent for a vacancy. It mirrors the sales side CMA process and helps the manager position the rental against the local market. A is wrong because a USPAP compliant appraisal report must be performed by a state licensed or state certified appraiser. A property manager's rental analysis is a management tool and is not held out as a formal appraisal. B is wrong because a federal LIHTC compliance audit reviews a low-income housing tax credit property for IRS compliance. It is a compliance review, not a rental pricing analysis for a market rate vacancy. D is wrong because A. 1031 like-kind exchange filing is a tax-deferred exchange of investment real estate under IRC Section 1031. It is a tax compliance matter, not a rental pricing tool for vacancies. Just as a listing agent studies recent sales to price a home, a property manager needs a way to price a vacant rental. That tool is the rental market analysis, sometimes called a rental comparative market analysis, and it applies the same comparison logic to rents instead of sale prices. Price a unit too high and it sits vacant, losing income every month it's empty. Price it too low and the owner leaves money on the table for the whole lease term. A rental market analysis grounds the number in evidence instead of a hunch. The manager gathers rents for comparable units nearby, adjusting for size, condition, amenities, and location. The analysis also weighs operating expenses, a vacancy allowance, and any local rent control limits. Together, these produce a supportable rent grounded in real data. Keep this tool separate from what it isn't. A USPAP appraisal is formal valuation work reserved for licensed appraisers. A LIHTC compliance audit checks subsidized housing rules, and a like-kind exchange filing defers taxes on a property swap. Only the rental market analysis is the manager's rent-setting comparison. Whenever a scenario describes a manager pricing a vacancy using comparable rents and operating data, that's the rental market analysis at work. The rental world's answer to the sales comparative market analysis. Questioner 46. A licensee in Atlantic City prepares a written contract for a vacant residential lot listed with the broker. Once both parties sign, the standard New Jersey attorney review notice in the contract starts the 3 business day clock. Which of the following best identifies who delivers that notice? Your options are A. The buyer alone, B. The seller alone, C. The real estate commission, D. The licensee preparing the contract. Which would you go with? Lock it in before the reveal. The correct answer is D. The licensee preparing the contract. D is correct because the licensee who prepares the standard form contract delivers the attorney review notice along with the executed contract. Notice of the right to attorney review must accompany the contract under the 1983 consent judgment. A is wrong because the buyer alone is not the deliverer of the attorney review notice. The licensee includes the notice in the standard form contract at signing. The buyer can later disapprove through counsel but does not deliver the initial notice. B is wrong because the seller alone is not the deliverer of the attorney review notice. The licensee preparing the standard form contract includes the notice as part of the document, and either party's attorney may then disapprove the contract. C is wrong because the real estate commission does not deliver attorney review notices to private parties. The commission writes rules and disciplines licensees. Transactional notice obligations belong to the licensees who prepare the contract. When a licensee prepares a standard New Jersey real estate contract, that same licensee must deliver the attorney review notice with the signed contract, starting the 3 business day clock. This duty traces back to a negotiated settlement between the organized bar and the real estate industry. Licensees may prepare contracts on standard forms only if the notice of attorney review is included and actually delivered, giving either party a chance to have a lawyer disapprove the deal. The mechanism ties everything to signing. The licensee prepares the contract, the parties earn, and the licensee delivers the executed contract together with the notice to both sides. That delivery is what starts the 3 business day period during which an attorney may disapprove. The exam wants you to sort the actors correctly. The buyer doesn't deliver it. The seller doesn't deliver it. And the Real Estate Commission only writes rules and disciplines licensees rather than handling transactions. Only the preparing licensee delivers the notice. The privilege of preparing the contract comes with the duty of delivering the review notice, since that safety valve is what justifies letting non-lawyers draft contracts in the first place. Whenever a STEM asks who delivers the attorney review notice, the answer is the preparing licensee. Question 47. A large national lender contracts with a third-party firm that selects, engages, and pays individual appraisers for residential mortgage appraisals, shielding the lender's loan officers from any direct contact with the appraiser. Which type of firm best describes this third party? Your options are A. An appraisal management company, AMC. B. A title insurance company. C. A real estate brokerage firm. D. A real estate investment trust. Don't overthink it, which one feels right? The correct answer is A. An appraisal management company, AMC. A is correct because an appraisal management company stands between a lender and individual appraisers. AMCs select, engage, and pay appraisers and help separate loan production from appraisal selection. New Jersey regulates AMCs under the Real Estate Appraisers Act regime. B is wrong because a title insurance company underwrites and issues title insurance policies to owners and lenders. It conducts title searches and clears defects but does not order or manage real estate appraisals on a lender's behalf. C is wrong because a real estate brokerage firm represents buyers, sellers, landlords, and tenants in real estate transactions. It does not manage the appraisal panel for a lender, an activity that falls to specialized appraisal management companies. D is wrong because a real estate investment trust pools capital to own, finance, or operate income-producing real estate. It is an investment vehicle, not an intermediary that engages independent appraisers for a lender's loan files. After the housing crash, regulators saw that appraisals had been bent by pressure from the people who profited when loans closed. The Appraisal Management Company, or AMC, became the structural fix. A loan officer whose pay depends on closing a deal can pressure an appraiser to hit a number. The AMC stands between lender and appraiser, so the two never negotiate value directly. The AMC maintains a panel of independent appraisers and handles the administrative work, selecting, engaging, reviewing, and paying. The lender gets a finished report without ever picking or pressuring the person who wrote it. A title insurance company searches and insures title. A real estate brokerage represents buyers and sellers. A real estate investment trust pools capital to own or finance property. Only the appraisal management company selects, engages, and pays appraisers on a lender's behalf. The AMC model improves independence by separating appraisers from loan officers, but it also inserts a paid middleman that can pressure turnaround and cost. That's why states regulate the intermediary itself. Question 48. An eligible veteran seeking a residential loan in Toms River qualifies for a zero-down payment government loan that does not charge private mortgage insurance and instead charges a one-time funding fee at closing, varying by service category and down payment. Which loan best matches? Your options are A. An FHA Section 23B loan. B. A VA guaranteed loan. C. A conventional conforming loan. D. A USDA Section 502 guaranteed loan. Got a guess? Lock it in. The correct answer is B, a VA guaranteed loan. B is correct because a VA guaranteed loan permits eligible veterans and service members to finance without a down payment, charges no private mortgage insurance, and assesses a one-time funding fee that varies by service category, down payment, and prior use of entitlement. A is wrong because an FHA Section 203B loan requires a small down payment and charges both upfront and annual mortgage insurance premiums. It does not have a one-time funding fee in lieu of insurance and is not limited to eligible veterans. C is wrong because a conventional conforming loan generally requires a down payment and private mortgage insurance for high LTV loans. It does not allow zero-down financing and does not assess a one-time service-related funding fee. D is wrong because a USDA Section 502 guaranteed loan targets rural moderate income borrowers with its own fee structure. It is not the veteran-only product the question describes and is geographically limited to eligible rural areas. A loan with zero down payment, no monthly mortgage insurance, and a single upfront funding fee is almost always a VA guaranteed loan. That combination is the fingerprint the exam wants you to recognize instantly. The government doesn't lend the money directly, it guarantees a portion of the loan a private lender makes. That guarantee substitutes for both the down payment and the mortgage insurance a conventional loan would require. Instead of paying mortgage insurance every month, a VA borrower pays one funding fee at closing. That fee varies by service category, down payment size, and prior entitlement use, and some disabled veterans are exempt entirely. FHA loans require a down payment and both upfront and annual mortgage insurance open to anyone. Conventional loans charge private mortgage insurance when the down payment is small, and USDA loans serve rural buyers with their own fee structure. Only the VA loan pays zero down and no mortgage insurance with a service-based funding fee. When a question describes a veteran borrower with zero down, no mortgage insurance, and a one-time funding fee, the VA guaranteed loan is the answer, set apart by that fee standing in for insurance. Question 14. A home buyer in Jersey City signs two documents at closing: a written promise to repay the loan to the lender and a separate document that pledges the property as security for that repayment. Which of the following best identifies the second document which creates the security interest? Your options are A, the promissory note, B, the closing disclosure, C, the mortgage, D, the deed of trust used in NJ. Which one is it? Pause the video if you need more time. The correct answer is C, the mortgage. C is correct because the mortgage is the security instrument that pledges the property as collateral for the debt evidenced by the promissory note. The note creates the personal obligation to repay. The mortgage creates the security interest the lender records. A is wrong because the promissory note is the written promise to repay the loan and creates the personal obligation. It does not by itself pledge the property. That pledge is the work of the mortgage, the second document at closing. B is wrong because the closing disclosure is the federal treaty document summarized in the final loan terms and settlement charges. It is informational and does not create a security interest in the property like a mortgage does. D is wrong because New Jersey is a mortgage state jurisdiction, not a deed of trust state. The security instrument used here is a mortgage that runs directly between borrower and lender, not a deed of trust with a third-party trustee. At closing, a borrower signs two documents that are easy to confuse, a promissory note and a mortgage. Understanding what each one actually does is the key to this exam concept. The promissory note is the borrower's personal promise to repay the debt. The mortgage is the separate document that pledges the property as collateral. It's the mortgage, not the note, that creates the security interest in the real estate. The note lists the loan amount, interest rate, and payment schedule, but it doesn't touch the property by itself. The mortgage is what attaches the debt to that specific parcel, and recording it in the county land records establishes priority and lets the lender foreclose if the borrower defaults. The promissory note is the personal obligation, not the security. The closing disclosure summarizes loan terms but creates no lien at all. And New Jersey is a mortgage state, securing loans directly between borrower and lender rather than through a deed of trust. The note can be sold as debt while the mortgage stays recorded against the property, securing it. 2 documents, 2 distinct legal jobs. Question 50. A buyer in Cherry Hill and a seller agree orally to convey a residential lot for a fixed price, and the buyer hands over a cashier's check the same day. Without a signed writing, the agreement is generally unenforceable in court. Which statute primarily produces that result? Your options are A. The NJ Consumer Fraud Act, B. The NJ Plain Language Act, C. The Realty Transfer Fee Act, D. The NJ Statute of Frauds. Take a second. Which answer would you pick? The correct answer is D. The NJ Statute of Frauds. D is correct because the New Jersey Statute of Frauds at NJESA 2501 Tucker 13 requires contracts for the sale of an interest in real estate to be in writing and signed by the party to be charged. Oral real estate contracts are not enforceable. A is wrong because the Consumer Fraud Act addresses unconscionable commercial practices, misrepresentations, and certain home improvement contracts. It does not provide the general writing requirement for real estate sales contracts, which comes from the Statute of Frauds. B is wrong because the Plain Language Act requires consumer contracts to be written in clear and understandable language. It is about readability rather than the existence of a written agreement, which is the issue when the parties never reduce their deal to writing. C is wrong because the Realty Transfer Fee Act imposes a fee on the recording of deeds at closing. It is a revenue statute that does not control whether an oral agreement to sell real estate is enforceable in a court action. Some promises are only enforceable if they're in writing, and selling real estate is the classic example. The Statute of Frauds requires certain agreements to be assigned writing to be enforceable in court, and land sale contracts fall squarely within it. The rule exists to prevent fraud and misunderstanding in the most consequential deals. Real estate involves large sums and lasting rights, so requiring a signed writing forces the essential terms into a fixed, provable form instead of relying on shaky memory or testimony. In New Jersey, this rule lives in Title 25, Section 1-13. It requires a writing, signed by the party to be charged, capturing the essential terms, or a court will generally refuse to enforce the deal. Don't confuse this with other statutes. A consumer fraud statute targets deceptive practices. A plain language statute governs readability, and a realty transfer fee is just a recording charge. Only the Statute of Frauds makes an oral land sale contract unenforceable. An oral deal isn't illegal, just unenforceable in court. Picture a Cherry Hill buyer and seller shaking hands and exchanging a check for a lot. Without a signed writing, a court still won't force the sale if one side walks away. And that wraps up today's full practice review for the New Jersey Real Estate Salesperson exam. If you'd like to keep practicing what we just covered, be sure to visit our website. You'll find hundreds of free practice questions waiting for you there, plus complete study guides designed to help reinforce everything we've gone through today. It's all there to support your learning. Links to everything are right down in the description below. Subscribe so you don't miss our next practice set, and good luck on your New Jersey Real Estate Salesperson exam.